The scope of the interdict he seeks is limited to the commencement of the public hearings. As far as the duration is concerned, our notice of motion makes it quite clear in prayer 1.2 that the interdict is sought only, and I quote, pending the determination by this court of the application for review. Now, and that hearing by this court has been set down for 2 to 4 September. So this interdict will run only when this court gives judgment on the debate which is to be had in early September. One imagines it would be sometime in September. So that's a very limited duration of a stay that the President seeks.
Well, that might be the argument by the President, but we know in practice what can happen is that if the review court does not find in favor of the President might appeal.
Yes, indeed.
And then that might stay the further proceedings.
With respect, not. All the President asks of you today is to give him an interim interdict until this court gives judgment. He's not asking for an interdict. So this court's interdict will expire when this court gives judgment.
Yes, I know that. That is asking. But the consequences thereof might be that if the review court is against your client, the President, then there's a highly likely chance of him appealing that.
And then it will be, then the matter will be governed by the Superior Courts Act, which has a system in place for whether judgments are suspended or not suspended. But it will then be for that court to decide whether to extend any protection. This court's order will expire when this court gives judgment in the review. What happens beyond that will be for that court to decide. My client hopes that he's going to win and will not require any further protection. But it's not an issue for you to decide today. We just emphasize in this context the timeline of this case, and we have adjusted in our heads. Now let me just emphasize the following features. The panel report was rendered in November 2022. There were skirmishes which came to nothing, and then in March 2023 the Constitutional Court dismissed both the President's and the EFF's attempts at direct access. That was in March 23. And then nothing happened for almost a year until the EFF launched their application to the Constitutional Court. And the Constitutional Court ultimately gave judgment only in May this year. Sorry. On the 8th of May, yes. So that these other parties who complain about delay today are the EFF who delayed for almost a year, and then all the other parties who did nothing for 3.5 years. So that, with respect, in the context of the delay that's already occurred, for which the President is not to blame, has already run for a long, long time, it doesn't justify undue further delay. But it does put in perspective the very modest application of the President for a stay protection of his rights for another 2 or 3 months. There are technical points that go with it. MK's argues, paragraph 37 of their heads, that the President should have brought this application in both his personal capacity and in his official capacity as the office of the President. But with respect, the President is here in his capacity as the current incumbent of the Presidency. That's the only capacity in which he is here, only capacity in which he has any interest in the matter. The office of the President is not an office with any interest in this case. Then MK also says in paragraphs 38 and 39 that the President should have joined the panel members. But with respect, the President did join them in the review, quite properly so. But they then filed notices to say that they abide and do not wish to participate in the review. So they have no interest in this interim entity at all, because they are not party any longer to the review. Can I then say something about the impeachment of the President, because this is the heart of the rights which the President seeks to invoke in his protection today. It starts with the EFF case. Well, there are lots of them, but this is EFF 2018. The reference is EFF, the Speaker of the National Assembly, 2018, Volume 2, SA 571, Constitutional Court, where the Constitutional Court said two important things. In paragraph 138, it said that the process of impeachment under Section 89 is a punitive process. There are other provisions in which the President can be removed by a motion of no confidence, and that is a political process with no punitive implications. But by contrast, Section 89 is punitive of the President. And then it says in Section 196 that in the result, because it's punitive, Section 89(1) implicitly imposes an obligation on the Assembly to make rules specially tailored for an impeachment process, so that the rules under which the impeachment process is being conducted are rules made under constitutional mandate to regulate that process. And we submit with respect that the purpose of the scheme of the rules and the purpose with which they have been designed is in the first place to hold the President to account if there is a complaint against him worthy of investigation. But at the same time, to protect the President against the humility, against the punitive impact of a public inquiry when there is no justification for it. And it's important to recognize that the rules are designed not only to facilitate an inquiry, but also to protect the President. And it protects the President by imposing a mechanism between the complaint and the inquiry. The complaint starts off with a prima facie case, which is required, and then it goes to the independent panel. And the independent panel reports on the question whether the complaint, whether there is sufficient evidence for a public inquiry. And it is the purpose of that requirement of an independent panel report is for the protection of the President. The independent panel itself, in fact, recognized that that was so. And we submit with respect, eloquently articulated the point when it said in paragraph 76, we think that the purpose of interposing the panel in the scheme of the impeachment process and entrusting it with the power to conduct a preliminary inquiry into the motion was intended to ensure that the President is not required to undergo full-scale Section 89 impeachment inquiry in circumstances where the President has no case to answer. That step, that's the inquiry, that step must never be taken lightly. It is a momentous act, justified only when sufficient evidence exists to show that the President has a case to answer. Now, we will submit to you that the panel got the test wrong, the prima facie evidence versus sufficient evidence. But what it did correctly is to recognize that the purpose of this independent panel process is to protect the President against the punitive effect of a public inquiry which without proper foundation.
So, do you understand your argument correctly? Is that the panel must establish whether there are sufficient evidence
Yeah.
to establish a prima facie case for the president to answer?
Well, let me say, we submit with respect that the panel erred in defining the level of proof required. For the complaint to get off the ground at all, before it goes to a panel, there has to be a prima facie case. The rules say so, and the speaker is obliged to ensure that there is a prima facie case. Then it goes to the panel. The panel investigates, and the panel reports. And the panel's mandate is to determine whether there is sufficient evidence for an inquiry. Now, the panel equated sufficient evidence with prima facie evidence. We submit with respect that it was wrong on that score.
But if one have regard to the latest judgment of the Concord of the EFF versus the Speaker that was delivered on the 8th of May, I think the Chief Justice has put it squarely in paragraph 141. What's the test of the panel?
Yeah, with respect,
It is the panel must go and inquire where there is sufficient evidence to establish whether there is a prima facie case for the president to answer.
well,
That is what the Chief Justice said in
Well-
paragraph 141.
well, with respect, my Lord, that issue was not determined by the Constitutional Court. The court did not purport to opine on the level of proof required at all. I know that there is that passing remark, but it was...
Is it a passing remark?
No,
If you read it in context, it can hardly be a passing remark.
No, with respect. The court did not purport to determine what that burden is. It is merely a passing comment in a sentence, in a paragraph that deals with something else. And with respect, it did not purport to consider what the implications are of the language of the rules. And remember, the language of the rules distinguish clearly between a prima facie case on the one hand and sufficient evidence on the other. The rules start off by saying that a complainant may make a complaint by providing prima facie evidence of misconduct by the president. That is the starting point. And the speaker has to check that it complies with that requirement. Only if there is a prima facie case does the complaint go to the independent panel. And then the rules say, and the independent panel must determine whether there is sufficient evidence
To do what?
for a public inquiry. Now, it firstly uses different language. It spoke of prima facie evidence, now it speaks of sufficient evidence. And what's more, it serves a different purpose. The starting requirement of prima facie evidence is an objective requirement. And there is, it's not a question of opinion, it's an objective requirement that must be satisfied for the complaint to get off the ground. Then it goes to the panel. It wouldn't make sense to say the panel must again determine whether the complaint makes a prima facie case. Makes no sense at all. And because if that were the
But isn't the
interpretation-
function of the panel to establish whether there are sufficient evidence for the president to answer the prima facie case against him?
No, with respect, that requirement has to be present before the case goes to the president. There, and that is what the rules say. And let me say this, that it is interesting that the rules draw that distinction between a prima facie case on the one hand and sufficient evidence on the other. And what is interesting, if one were to compare it with the rules prescribed for the removal of Chapter 9, for the head of a Chapter 9 institution. These are rules 129Q through to 129 AE. Now those rules, and by the way, a copy of these rules have been uploaded on case lines. They are at 013-351. And you'll see from those rules that they follow much the same pattern as the rules for the impeachment of the president. But there's an important, they're not identical, but they follow much the same pattern. But there is an important distinction between them. In those rules, Rule 129X small b says that the panel, also the independent panel, must determine whether there is prima facie evidence to show that the holder of a public office is guilty of misconduct. So the difference between the language of our rule and the language of this rule, both of them were introduced at about the same time, and the one set of rules follows immediately after the other. But there's this distinction that in our case, the rules require sufficient evidence, whereas in that case it requires prima facie evidence. So we submit with respect that where the rule already calls for a prima facie case before it goes to the panel, and then requires sufficient evidence, for a finding of sufficient evidence, that the two concepts are firstly expressed in different language. But if one is then contrasts them with the language of the comparable model for the removal of the head of a Chapter 9 institution.
So on your argument, if I understand it correctly, is this: the panel's function is to sift through the evidence and to decide whether it's sufficiently enough for the president to answer a case. Is that the answer?
Whether there is sufficient evidence for a public inquiry. It wouldn't make sense to reformulate the test as sufficient evidence to make a prima facie case. That just says a prima facie case. But whether there is sufficient evidence to warrant a public inquiry. And remember that that is
what will the impeachment committee then do? What will their function be? If the panel comes up and say, well, there's sufficient evidence against you to answer a case, and it's not prima facie, then it means that the impeachment committee can just follow it. They don't have to do anything else, because then the president is sort of guilty.
No, with respect not. The process provides for very limited evidence to be placed before the independent panel. Merely the complaint and information placed before it by members of the National Assembly. It's not a fully fledged investigation. And the question then is there sufficient evidence to go to an impeachment inquiry? No, the question is not, is the president guilty? Because that they can't determine that on the limited process that they use. But otherwise, what function do they perform? Before the matter gets to them, there has to be a prima facie case against the president. What is then the function of the independent panel? It can't just be to determine again whether there's a prima facie case.
Should there be prima facie evidence? Because obviously it is for the panel to sift all the information that's in front of them, whether it's hearsay, whether it's gossip, whether it's all sorts of allegations. They must sift that to see whether there is sufficient evidence.
Yeah. I've no qualms with that.
Okay.
But I just emphasize that there is limited evidence before the panel.
Okay.
And its function is to say to itself, there might be a prima facie case against the president, but it's a weighty step. The panel call it a momentous step to start an impeachment hearing against the president. Is there sufficient evidence to embark on such a momentous step. And that means you don't merely ask whether there is prima facie evidence. Remember, to determine a prima facie case, one generally looks at the evidence of the accuser without balancing it against the evidence of the defender. It's akin to the test of non-absolution. You ask yourself, is there evidence which, if believed, would constitute a case of misconduct? That is what a prima facie case is. But the panel is enjoined to receive not only the accuser's documents, which has already been certified as a prima facie case, but also other input from other MPs, and importantly, the President's own response to those complaints.
Tell me, is the complaint that the panel used the wrong test or they reached the wrong conclusion?
No, with respect, that they used the wrong test. I won't be here submitting to you that you should overturn their conclusion because I think they were wrong on the evidence before. That is not the test. The test is, did they apply the correct standard? Did they ask themselves the right question?
Now, if for argument's sake, court were to accept that the panel used the wrong test, would a new panel have to be then reconvened? That would not be misdirected, but it would still be confined to the same material which is largely common cause.
Well, it depends.
And you might end up with the same result.
It might indeed. I'm not arguing to you that a panel could never have come to that conclusion. What I'm arguing to you is that the President is at least entitled to the protection of a panel which asks itself the right question. Whether it then correctly answers that question or not is a different matter. But the question they have to ask themselves is there sufficient evidence for the momentous step of an impeachment inquiry? I'll come back to the other flaw in the panel's report to which we rely, insofar as they failed to recognize that they have to determine whether there is sufficient evidence not only that the President transgressed, but that he did so in bad faith. It didn't ask itself that question. But I'm not there yet, and let me just deal with one or two other preliminary issues before I get there.
But perhaps before you go on to that, if one looks at the tests the panel applied, one must also have regard to the tools at its disposal. It's got very limited tools. It cannot try fact, it cannot cross-examine witnesses, cannot call witnesses. It has to deal with what it has. And it's from those materials that it makes an assessment, whether they're sufficient, prima facie, whatever. But at the end of the day, they say, before us is sufficient material, we think the President has a case to answer. Whether you label as sufficient or whether you label as prima facie, whatever the case is, this is the evidence before us.
With respect, it's a little bit more than that. The question is not whether there's a case to answer, because remember, they already sit with an answer in front of them. The question is, having regard to the evidence incriminating of the President and the President's answer, is there sufficient evidence for this matter to go to trial, to go to an impeachment inquiry? That is what they ask themselves. And what it recognizes, because a prima facie case is required to get out of the starting blocks at all, what is the purpose of requiring a panel, and a panel that determines whether there is sufficient evidence? The panel has to consider the incriminating evidence. The panel has to consider the President's explanation, his response, and say to itself, not is he guilty or is he not guilty, but is there enough of a case to go to trial? That is what they need to decide. And it's a greater responsibility than merely determine whether it's a prima facie case. Prima facie case is a very mechanical exercise. This is a judgment call that they have to make, because an inquiry, as the panel has said, referral to an inquiry is a momentous step, and for that there is the rules require a little more than just a prima facie case.
But just to add on what my learned brother said, is that the tools available to the panel was they had to deliver a report within 30 days. They can't call witnesses to testify. They can't cross-examine them. They can only work on affidavit. And the only affidavits that they had in front of them were those that was given to the panel, including the answer by the president. Now, viewing that, they then came to a conclusion that there's certain gaps that the president needs to answer.
No, with respect not. They said there's a prima facie case. There's a case to answer.
Yeah.
And that
So
is
what's wrong with that?
Well, what's wrong with that is that that merely looks at the incriminating evidence.
No, they also looked at the evidence of the president.
They never weighed up.
Oh, okay.
They never weighed up the evidence to ask themselves, is there enough of a case to warrant an inquiry, a public inquiry? And so that I know that they looked at the evidence, but they concluded by asking themselves the wrong question. They concluded by asking themselves, does the evidence make a prima facie case? Well, that is to say, do the accuser's evidence make a prima facie case? Prima facie case means, if you take this evidence at face value, does it make a case against the president? Sufficient evidence requires something more. It requires that there is enough evidence for the punitive step of a public inquiry. There is a contention by some of our friends that the Constitutional Court's judgment compels this inquiry to proceed, and therefore that this court does not have jurisdiction to issue the interdict sought by the President. But with respect, that is not what the Constitutional Court judgment says. The Constitutional Court had before it an independent panel report under Section 129I. That section provided that if the panel recommends a hearing, its recommendation is considered by the National Assembly, which may overturn it or not. And for that reason, the Constitutional Court held the 129I to be unconstitutional, and it replaced it with a rule that says that if the independent panel finds that there is sufficient evidence, then it must go to the Impeachment Committee. If the independent panel finds the other way, finds that there isn't sufficient evidence, well, then it's for the National Assembly to decide. So the ratio of the Constitutional Court judgment was that the rule was invalid, and because the rule was invalid, the National Assembly, the decision taken under it, was also set aside. So and therefore said the Constitutional Court, under the rule as reformulated, the panel report must go directly to an impeachment committee. That's what the court said. So the outcome of its judgment is that the report is now before the impeachment committee. But that says nothing about the validity of the report. The report has not been tested, and the Chief Justice in her judgment made it clear that the inquiry must then proceed unless the report is reviewed and set aside. So the effect of the judgment is not to preclude a review of the report.
What is your argument with regard to some of the respondents saying that, in fact, the President should have gone back to the Constitutional Court to raise this issue there? Is that the answer now that you've given us?
Yeah.
Okay.
And they say that only because they assume or say that this review flies in the face of a Constitutional Court order. We submit with respect that that is not so. The Constitutional Court the effect of the Constitutional Court order was to set aside to replace the rule, to set aside the National Assembly decision, and under the new rule, to say that now the report must go directly to the Impeachment Committee. That is where we are, and that's the effect of the Constitutional Court judgment. The Constitutional Court didn't say, and the report will no longer be reviewable. Where along the way did the President lose his right of review? That is not an implication of the order.
But by the same token, the Constitutional Court order says that the Constitutional Court order says that the impeachment process must continue.
Well,
Unless and until the review is instituted. But in this case, it didn't say pending a review.
I don't think that the order said, and it must continue pending a review. That was a comment made by the Chief Justice in the course of her judgment. But I'm not suggesting that that is not how their judgment should be understood. The order itself simply said, paragraph 7 of the order, the report of the independent panel is referred to the impeachment committee established in terms of the National Assembly rules. So that is where it now is. The Chief Justice has said in her judgment that when such a referral happens, the impeachment committee proceedings continue unless and until the report is reviewed. So, and here we are. We're under the unless and until a review happens. Our friends for the ATM argue that such a report is not reviewable because it is a midstream or an intermediary step. We address that issue in our heads of argument from page 12 in paragraph 33 through to 40. And I won't recite the authorities again, but what all of them say is that whether a decision is ripe for review depends on whether it causes or may cause prejudice. That is the touchstone. The one case was of a child who was suspended from school. It's not a final suspension, but the court said it causes sufficient prejudice for that decision to be reviewed, even though it's not a final decision. And then in the cases from there, that was from Wyke's case, and cases after that, Save the Val, the SCA case, Earth Life Africa case, and the Rhino Oil case, all of them say the touchstone for ripeness is prejudice or potential prejudice. So we submit with respect. The question is not technically. Oh, let me say, the report, of course, is in its own terms final. It's not a provisional or preliminary report. It's a final report. We accept that it is a step in a longer process, but it is a necessary step. And if it is not valid, then its invalidity causes damage to the President of the kind of which he's complaining. So we submit that the midstream complaint is not correct.
So are you suggesting that the report is in fact the trigger for the impeachment committee to be established?
It's a trigger for the process which the Court has held to be punitive. And that is also the President's own objection. He says it's humiliating, it is insulting for me to be the subject of a public hearing of impeachment. And the rules entitle me to the protection of a lawful independent panel report. So I'm entitled to test the lawfulness of the report, and if it is not lawful, then I'm entitled to an interdict of the next step, i.e. the inquiry. Can I just come back to the issue to which you've taken me before? and that is the difference between a test of a prima facie evidence and a test of sufficient evidence. And let me say that I know that the members of the bench have much experience in the application of both tests. Well, sufficient evidence is a new test. But prima facie case, and let me just emphasize the following features of a prima facie case. The question is there prima facie evidence of misconduct? That is evidence which, if accepted, would make a case, e.g., of misconduct. So the question, you look at the evidence, you don't weigh up the evidence. You simply say to yourself, if this incriminating evidence is accepted, does it make a case against the president? The important features is that it takes evidence at face value. It does not assess its credibility or its weight. It does not weigh up the evidence against anything else. So that it is hard to understand why, if the question before the panel is merely whether there is prima facie evidence, what are they meant to do with the president's countervailing evidence? It doesn't make sense to say that you must give the president an opportunity to respond. You sit with his response before you, and then you ask yourself, is there a prima facie case, which doesn't weigh up his evidence at all. It does make sense if you say, is there sufficient evidence to go to a public hearing, which says more than just a mechanical assessment of whether there's a prima facie case. It says, given the momentous step, given the punitive impact, is there enough evidence to go to an impeachment inquiry? And I don't say the question is whether the president is guilty or not. I accept that that's far away from it. But you say to yourself, is there enough evidence to justify this momentous step? And that is the question. That is the question the panel didn't ask itself. It simply said, is there a prima facie case? And by asking itself the wrong question, it applied the wrong test. It deprived the president of the protection of the requirement that there be sufficient evidence for the momentous step of an
But
inquiry.
Mr. Trengrove, on the papers before us, there is quite, it is evident that the panel just didn't follow one set of evidence and disregarded the other set of evidence. There is clear indication on the record, and we don't have to decide that, but that's for the review court, possibly.
No, what
That they did consider it. They did make certain comments about the evidence.
I accept that they sometimes did and sometimes didn't. But at the end of the day, you won't find in their report any weighing up of the accusation and the defense. They sometimes recited it, sometimes made mention of it, but sometimes not. But then the question they ask themselves is not, where do we go from here? Is there enough evidence for a public inquiry? They said to themselves, is there a prima facie case?
Yeah, but I'm getting the impression sitting here is that the president thinks that, listen here, my evidence that I give must weigh heavier than all this, as he terms it, hearsay evidence from his accusers.
Well, let me say, firstly, in defense of the president's indignation. His indignation is an understandable human reaction. To say,
of course, yeah.
I'm confronted by evidence of undisclosed origin. A man turns up and he gives an account and he doesn't tell us where he gets it from. I was there, I know what happened, let me tell you what happened. So his indignation is justified. But that's not my argument. I'm not suggesting that his evidence should count more than the incriminating evidence. But what I am suggesting is that you owe it to him under the rules, at least to have, the panel owed it to him under the rules, at least to have regard to his evidence, and in the light of his evidence to say, well, is there enough to go to take the momentous step of going into a public inquiry? That is the question they ought to have asked themselves.
Oh, are you suggesting that they didn't do that?
Yes, indeed. They made it quite clear that they merely said, is there a prima facie case? That's all they
No, what I'm saying is, are you suggesting that they did not consider the President's evidence?
No, I'm not suggesting that. We know that they do. They sometimes recite it. But then they say to themselves, when it comes to decision time, they say to themselves, is there a prima facie case against the President? And frankly, if that is the question you ask, then the outcome is inevitable, because the Speaker had already determined that there is a prima facie. It doesn't get out of the starting blocks if there is a prima facie case. So I'm not, you asked me before whether we contest the answer the independent panel gave to the question. Not at all. That's not why we're here. But it asked itself the wrong question. Nobody can tell what its answer would have been if it had asked the proper question, which says, given in the light of all the evidence before us, the accusers and the President, is there enough of a case before the President? Is there sufficient evidence before us that the President should stand trial in a public inquiry? But that was, and you'll see, for instance, we mentioned two examples in our heads of argument of two of the complaints against the President. The one is that he had engaged in, quote, other paid work in breach of the Constitution. The other complaint is that he failed to report the theft on his farm under Section 34 of Trekka. Now, in both those instances, the panel came to a conclusion purely on a prima facie basis. There is no assessment, firstly, whether there's sufficient evidence, and then importantly, the second requirement is not merely that there must be sufficient evidence. The second requirement is that there must be a case, whether a prima facie case or sufficient evidence case, that the President acted in bad faith, that he intentionally committed these acts of wrongdoing. That is so because
But isn't that really that determination? Doesn't it lie with the impeachment committee to decide that, and not the panel? The panel merely must decide whether there are, as you term it, sufficient evidence for him to answer. And then he goes and answers and says, listen here, I reported this matter to my chief of staff, that's security there, and asked them to go investigate.
You ask a legitimate question, and that is why they should have asked themselves whether there was bad faith. Under the rule, Rule 129 defines serious misconduct. The two grounds for impeachment of the President is either serious misconduct or a serious violation of the Constitution or the law. Now the rules define both of those concepts in its definition section. It says serious misconduct means unlawful, dishonest, or improper behavior performed by the President in bad faith. It's not an impeachable offense if it is not in bad faith. That means intentional. The serious violation of the Constitution or the law means behavior by the President amounting to an intentional or malicious violation. So for the misconduct to reach the level of an impeachable offense, we must find that the President intentionally transgressed the rule. In other words, that he knew of the rule and intentionally transgressed it. Now, of course, the panel cannot find conclusively that the president acted in bad faith or not. But what the panel must at least ask itself is there prima facie evidence or sufficient evidence on my standing? Is there evidence that the president acted in bad faith? And the panel never asked that question. In relation
But is that the panel's function, to ask that question?
well,
Or is it the impeachment committee's function ultimately to decide whether these accusation against the president reaches that level?
No, you're absolutely right that it is ultimately for the impeachment committee to determine. But you can't denude the function of the independent panel to render it meaningless. Remember, you must accept that there's a prima facie case that comes up to the panel. Now, I've already submitted that the panel must then ask itself, is there sufficient evidence for it to go further? That's the one. But the second question is this. The panel must ask itself whether there is evidence of a willful or mala fide transgression by the president. And it needn't decide the issue, but what it must do is to ask itself, on this evidence, did the president act willfully or in bad faith? And with respect, I again don't suggest that it got the answer wrong, but it didn't even ask the question. If you look at its assessment of at least two of the charges, the underpaid work charge and the Section 34 of Preka charge, in both those instances, the panel simply described the evidence before it and said, and therefore there is prima facie evidence that he was guilty of these offences. It never asked itself the question whether there is prima facie evidence or any evidence that the president acted in bad faith. And if you take the example, for instance, where the paid work example, the president's defense there was, remember the paid work complaint is that he's a farmer and he has a farming business and therefore he's impeached. The president's defense is that I always understood it to be lawful for a member of the executive to hold shares or invest in a business. I never understood that to be against the rules. We submit with respect that he's right, that the panel misinterpreted that rule, but that is not the point for present purposes. The question is not only whether he misunderstood the rule, but the question is whether he, in bad faith, became and stayed an owner of the business, knowing it to be against the rules. There's no inquiry into that question. On the contrary, the president's conduct contradicts any suggestion to that effect. He makes it clear that under the disclosure requirements of members of the executive, they are required to disclose any interest they have in businesses, shares in companies and the like. And that he disclosed his interest in the farm under that provision. So says the president. I don't agree with you. I don't understand my conduct to have been wrong. And in that regard, with respect, he said, but the president is right and the committee got it wrong. But that's beside the point. The president at least says, I acted in good faith. And the committee never inquired into that question. It can't come to the conclusion that there's prima facie evidence that the president acted in bad faith when it never asked that question. It never answered.
But the panel, as I understood it, did in fact inquire into issues relating to bad faith, like the concealment, for one, the use of the protection unit. They made comments on that.
Yeah, but with respect, the question is, in relation to each one of the charges, whether the president acted in bad faith. There may be other issues on which they were critical of the president's conduct. But the question before them is, is there sufficient evidence that the President acted in breach of Section 95 of the Constitution and that he did so in bad faith? They never investigated whether he transgressed that section in bad faith. Never. There's not a word about it. The same goes for the Trekker report.
I mean, just at the practical level, what would an investigation have entailed, given the tools they had at their disposal and time? What sort of investigation were they to conduct?
I'm not suggesting that the panel should have done any further investigation, but it should at least have asked itself the question on this evidence: is there sufficient evidence or prima facie evidence, whichever test you apply? Is there prima facie evidence that the President acted in bad faith? And it never asked that question. I submit with respect that on the evidence, take the ownership of the business. There was no basis upon which it could find against the President. But I'm again not here to argue that it got that its answer was wrong. I'm urging you to look at their report and to recognize that they never even asked the question. And that is the point. I'm not here to say they should have found differently. But I am here to say.
So if I understand you correctly, is that the panel omitted to go through each charge against the President and say whether the evidence is sufficient or whether it's prima facie evidence that we've got in front of us, and to consider whether he acted in bad faith on each of those charges. They may have made some other comments of how he used his personal security to investigate this matter, etc. And criticism against the money in the sofa, etc. But the real issues at hand is the 4 charges, I think. So on that score, the complaint by the President is that the panel didn't weigh it up properly because they never asked the question whether I acted in bad faith.
So
but can't we read that into it and say, well, they must have considered it?
No.
It's like any judgment. I mean, you can't get everything in a judgment.
No, but if you manifestly ask the wrong question, then there's no indication in the judgment that you did something else. The panel never asked itself did they act in bad faith, and on these charges. There are other discussions about whether the President was in good faith or not, but they never recognized that on each one of these charges, it is an element of the offense that the President acted in bad faith. And they have to ask themselves, is there prima facie evidence, if you would, that in relation to the farm, the President became and remained the owner of the farm, well knowing that it was unlawful to do so, in other words, in bad faith. They don't need to, there needn't be an answer to that question. They may say to themselves, well, he'd only be guilty if he did this in bad faith. And I assessed for the following reasons that there is a prima facie case that he acted in bad faith. But it cannot ignore the requirement and not consider it, because then there is not, even on its own reasoning, there isn't a prima facie case that the President committed the offense, because it is an element of the offense that he acted in bad faith.
You see, my difficulty with that proposition is this, is that if we allow the panel to go that far, then the Impeachment Committee, what must they do? So then they are sort of prescribed by the panel. The panel's already made a credibility finding on certain issues. So then they sit here on a credibility finding by the panel. So what must the Impeachment Committee do?
Well, the panel shouldn't make credibility findings at all, because
it's going to do that if it says that the President didn't act in bad faith.
No, but with respect to the law, I didn't say that it must find that the President acted in bad faith at all. That's not my submission. My submission is that it must ask itself the question, is there prima facie evidence that the President acted in bad faith? And I don't know what it would have said if it asked that question, because it never asked the question. The EFF say in their heads of argument, in paragraph 68,
Paragraph 68 of the head.
of their heads of argument, they say that the panel considers whether the president has acted in bad faith, and it refers to the panel's report in paragraphs 60 to 63 and 263. But with respect, in paragraph 60 to 63, the panel describes the element of bad faith. But at that point it describes the legal requirements for these charges against the president. It doesn't apply the law to the facts at all. It's merely a theoretical exercise. And then when they get to paragraph 263, those are merely its final paragraph. It's its final conclusion. And if you look at its conclusion, in paragraph 263.1 on the paid work charge, and 263.2 on the prepper charge, they just two.
Sorry, 216?
263 of the panel report. It's a panel.
Yes, just give me a second to get there. Yes.
My learned friend says it's at page 184.
Yes, it is. Thank you, Mr. Mpofu.
And you'll see in both those paragraphs, the 263.1 and 263.2, the panel merely concluded that there is prima facie evidence that the president committed those two offences, but there's no consideration of the bad faith requirement. So the EFF's suggestion that the panel indeed considered the bad faith requirement is with respect not correct. The MK argues in their heads of argument at page 16 in paragraphs 66 to 69. They argue on the evidence that the president acted in bad faith. But we submit with respect that that misses the point. We're not saying that there wasn't evidence that the president acted in good faith or bad faith. That's not the point we make. The point we make is that it is for the panel to determine whether prima facie or sufficient evidence. It's for the panel to determine, and the panel never asked the question and never made the determination. So that it doesn't help to argue that on the evidence there was sufficient evidence that the president acted in bad faith. So the effect of what the panel did was to deprive the president of the protection designed for the president to protect him against the momentous act of a public inquiry into his impeachment. That is, and to understand the importance of that error, let me say this. Section 89, as we've seen in the EFF judgment, Section 89 requires the National Assembly to make the rules for the impeachment process because it is a punitive process. And under those rules require interpose between the complaint and the inquiry. They interpose an independent panel, and it is clear, as the independent panel recognized, that the purpose of that interposition, independent panel process, is to protect the president against the momentous step of a referral to the committee without sufficient reason, without a proper consideration by the independent panel. The report is today even more important than it used to be before the Constitutional Court amended Rule 129I. Because today, if the report finds sufficient evidence of improper conduct, then the report flows straight to the Impeachment Committee. Previously, it first went to the National Assembly where it got voted down. That step, that protection has now been cut out in the sense that a negative report flows straight to the Impeachment Committee. So the importance of the protection of this buffer placed between the complaint and the Impeachment Committee, that buffer is all the more important today than it used to be. And its avowed purpose is to protect the President. And if the report is flawed, then with respect, the President is deprived of that protection, that Section 89 and the rules designed for him, for his protection. And he should not be exposed to an impeachment inquiry without that protection. The ATM says in their heads in paragraph 29 that the President suffers no harm at all, let alone irreparable harm, by having to testify before the committee. His harm complaint applies to every single witness in commissions of inquiries, statutory inquiries, and the like. But that, with respect, is to misunderstand the purpose of that buffer. The buffer is interposed specifically to protect the President against unjustified inquiries. And if he is not just another witness at a commission of inquiry. The rules recognize that the step of an impeachment hearing is a punitive step. It is designed to protect the President, and he would be deprived of that protection if a matter goes into an impeachment committee without a valid independent panel report. Takes me to the balance of convenience. Our learned friends say much about separation of powers harm. In response to that is, remember, we have here two branches of government. The Parliament, National Assembly on the one hand, and the President as head of the executive on the other. So there's no reason for the court to treat the one more sympathetically than the other. They both deserve protection in the independent arm of government. And the Constitutional Court, since the Outer case, amplified the importance or significance of the consideration of separation of powers harm. They did so in ESCOM Holdings, the Vaal River Development Association, 2023, Volume 4, SA 325, Judgment of the Constitutional Court, Mr. Justice McLanga, where he considered the significance and the impact of outcome. And then he said this, after having articulated the consideration of separation of powers harm. He said this: that courts must never lose sight of the fact that this remains a balancing exercise. Affected fundamental rights must always play a critical role in that balance. And in some cases, the affected rights may be of such a nature and their breach so grievous that they may influence a decision in favor of the victim of the rights violation, even in the face of highly policy-laden and polycentric executive decision. The ultimate question is, what is the outcome dictated by the balancing exercise? So you have to ask yourself, in this application for an interim interdict, you have to weigh up the balance, prejudice on one side to the prejudice on the other. And when one does that, a la ESCOM holdings, in this case, just ask yourself, where does the balance lie when all the President is seeking is a stay for 2 or 3 months? That's all he's asking for. In this matter where there's already been delays attributable to other people and not the President, there's been delays of almost 4 years. All the President says is, give me a chance, stay this process until this court has determined whether the independent panel's report is lawful or not. And that determination is likely to come in the course of September. So all he's effectively asking is for a brief stay of the public process, the punitive process, to afford him the protection to which he is entitled under the rule, and of which he would be deprived if a hearing takes place, despite the absence of a lawful report. The respondents who complain about the delay have done nothing for a long, long time. EFF was the quickest to act, but even they took a year to act, almost a year. The other parties have done nothing. The delay has been 3.5 years. The question is, what harm will it do if the hearing part, the Commission can start its preparations, preparatory steps, but if the hearing is delayed for a further 2 or 3 months, we submit and expect that the balance of convenience is overwhelming. Wherever the rights and wrongs may ultimately be found, no discernible harm will be done by a particular delay of a further 2 or 3 months. Very significant harm will be done to the President if the hearing goes ahead and it is ultimately found that the report was invalid, because then that harm would be irreparable.
But what would be that harm if it was so irreparable? If the hearing had to go ahead and the panel report was set aside?
Well, because you can never undo the harm done by an impeachment inquiry.
What would be the harm, though?
Well, reputational harm.
Reputational harm?
Yes, indeed. And I mean, that is the reputational harm against which the independent panel process is designed to protect the President. If it hadn't been for that implications for the President, that he is publicly tried on a charge of serious misconduct. Misconduct which, if he's guilty, would not only disqualify him as President, but would disqualify him for life for any public office or any benefits from the presidency. So that public humiliation will do its harm even if the report is ultimately overturned. Because the report is an intermediate step. It is designed to protect the President. If he's deprived of that protection, then he suffers exactly the harm which the rule intends to protect him against.
But on that score, what the respondents are saying is that his defense is already in public domain. So, what is the real harm then, as my learned colleague has indicated? Because his defense is in the public domain.
No, exactly, and that's why the President says, I'm not trying to protect the disclosure of the full facts. He says, I've already disclosed them. So that's not why I'm here to protect. What I don't want to be exposed to is to be publicly tried for a grievous offense committed by a President in office. That is a humility against which the rules protect him. And if the price of that protection is a delay of 2 or 3 months, that's the price of the protection. It is a scant price, if the risk to which you expose the president without that impeachment is that he will publicly pillory as a president who committed a grievous offense. That's the humiliation of it. And as I say, it's got nothing to do with keeping the facts secret. The president has already made full disclosure of the facts. They're public record. So he's not here in an attempt to conceal anything. He's here to protect himself against the public humiliation of a trial, of a grievous
No, I
offense.
still grapple with why would it have to be a humiliation? It could be an exoneration. If he puts his case before the inquiry panel, he's got legal representatives, he can air his views there in full public glare. He could come out much better than he is now. It could exonerate him.
Yes. Well,
It's just not axiomatic that because he goes to a public inquiry he's going to be humiliated.
no, what is axiomatic is that it's humiliating to put a president on trial. That's axiomatic.
But there
Regardless
have been other presidents, like President Mandela, who in fact went into
Yeah.
the witness box.
But
It didn't bring the house down.
with respect, we're now in a democratic society. We don't put presidents on trial.
But
Unless
when
it-
President Nelson Mandela went into the witness stand, we were in a democratic society.
Yeah, he was a witness.
Yeah, and they self-admitted.
Yes, I was his counsel. So no.
Well, and look how he came out.
No, exactly. We're
So,
not suggesting
and even the
that-
chairperson of the committee says that, listen here, I'm the chairperson, I'm here to protect our president. He's our president. I will not allow him to be intimidated. So what harm is there that
Well,
he will suffer?
what you're suggesting to me is that the buffer built into the rules is pointless because presidents don't suffer harm if inquiries are held. But I'm urging you to adopt the decision made by the legislature to build in that buffer in recognition of the fact that even to put a president on trial without good reason is a momentous step which should not be taken lightly. That is why the buffer is put in there. And the counter-arguments that you suggest to me would suggest that that buffer is not necessary at all because the president may be acquitted and therefore vindicated and therefore no harm to him on trial. We submit with respect that the purpose of the mechanism is to afford the president that protection. And he's here to claim that protection. And if there's no answer to say to him, but you don't need it. With respect, he's entitled to it, and he's entitled to it because the process is demeaning.
But Mr. Trengrove, as the president is the first citizen of this country, I mean, for heaven's sake, yes, he needs protection against frivolous accusations. But as the respondents indicated, it could be the panel, or not the panel, sorry, the committee, could say, but listen, these are all unfounded allegations. As my colleague has indicated, they're going to exonerate him. Isn't that sort of the step in the right direction in an open and democratic society? What buffers should there be for presidents?
Well, with respect, my lord, that question is not a question before you because it's
I know that, but I couldn't, prevent myself from asking the question.
You're absolutely welcome, and I understand that. But I can just reiterate. Firstly, that the National Assembly built in that buffer in recognition of the fact that it is humiliating for the president to be put on trial for serious misconduct if there isn't sufficient reason for it. That's just a legislative choice that has been made. And you're not asked to determine whether it was a necessary step or not. The legislature has created that buffer to protect the president against what some think is unjustified harm if a president is put on trial without good reason. And all the president is asking this court is not to determine whether it's a good idea or a bad idea to have a buffer. there is a buffer, and he's entitled to it, and this court should not deprive him of it, because the legislature intended him to have it.
Kind of, if I may ask, it seems to me that you're arguing for some sort of qualitative assessment by the panel. So it's going beyond a prima facie case. It's some sort of qualitative assessment of the quality of the evidence to see whether it's merits going forward. Because we know, of course, that it's for the impeachment committee to test the veracity. So that qualitative assessment must fall short of testing the veracity. What I'm asking is, what really is the panel supposed to do, given that they can't call people in, they can't get more evidence, they're very limited in their scope. Probing what does that qualitative assessment involve really, given that you say it's not enough to just ask, is there a case to answer? It goes beyond that. So I'm asking you really, what are they supposed to make of this?
Let me say firstly, I appreciate your pointing to the fact that they are required to make a qualitative assessment, because I should have made that clearer. But that's absolutely right, and that's the difference between their task and the speakers. So the speaker checks that there's a prima facie case. The committee must make a qualitative assessment. The test, the question they must ask themselves, is there sufficient evidence to go to a public inquiry? And I know you're asking me, what does that mean? Let me just say before I do so. The understanding that they're required to make a qualitative assessment is reinforced by the requirements set for the membership of the independent panel. That is under Rule 129E. It says the panel consists of 3 fit and proper, competent, experienced, and respected South Africans, who may include a judge, and who collectively possesses the necessary legal competence and experience. So it contrasts with the exercise done by the speaker, which merely asks whether there is a prima facie case. It comes before the panel. The panel is required to be people of high integrity and respect and judicial knowledge. It reinforces the understanding that they are required to make a qualitative assessment. And I submit with respect to get to your question. The qualitative assessment is this: they must ask themselves not merely is there a prima facie case, which is a mechanical exercise that looks at one side only. They must ask themselves, having regard to all of the evidence before us, recognizing that it's incomplete, but having regard to the evidence before us, both the incriminating evidence and the exonerating evidence. Is there enough of a case here to justify the momentous step of going to a public inquiry? So the qualitative assessment doesn't merely say, is there a prima facie case?
But on your further argument, the further step is also whether the president acted in bad faith.
Yeah. There are two requirements. The first is there, and you must firstly make that qualitative assessment. The qualitative assessment must be, the question there is not merely whether there's a prima facie evidence, but is there enough of a case against the president to warrant going to a public inquiry? That's the question they ask themselves. And that's why they put skilled people, respected people, on that panel, in recognition of the fact that this is not just a prosecution decision. This is a qualitative assessment on the question whether all of the evidence justifies the momentous step, as the panel called it, of going to a public inquiry.
Mr. Trenkrup, you've got about 5 minutes left.
Thank you, Lord. I just lastly wish to address the questions of urgency and submit there that the President has made it clear that the urgency lies in the fact that this inquiry is imminent, and if he is not protected against it, that he will suffer the harm against which the buffer is meant to protect him. The President decided to review. It's suggested that the President's urgency is of his own making. But the Constitutional Court judgment was given on the 8th of May. The President decided on the 14th of May to take it on review. So he took less than a week, 6 days, to take a decision to take it on review. But he was required to get the consent of the Chief Justice and the Judge President to cite the panel members who were judges. He immediately asked for that consent, and he received the consent on the 20th and 22nd of February. So only on the 22nd of May. So only on the 22nd of May could he launch, and he launched within days on the 26th of May. At the same time, you'll see in his founding affidavit in the review, he concluded it by speaking of the way forward. He said, I don't know whether they will insist. I will speak to the National Assembly. I will ask them whether they intend to proceed once they've seen this application for review. If they don't agree to stay, then I'll have to launch an investigation. And that is what he did. The chair, he asked for the chair to agree to a stay. The chair declined on the 9th of June. The President launched his stay application on the 12th of June. We submit with respect that there was no undue delay on the President's part, and if he were refused protection, he would suffer irreparable harm by being deprived of the benefit of the buffer designed for his protection.
Is that it?
Almost. There is an allegation by MK that the President is guilty of abuse of process. MK makes this allegation in paragraphs 41 to 43 of its answer. The President, they say, make the point that the President did not respond to their accusations that they make in those paragraphs. The accusations were made in paragraphs 46 to 55 of their answer. But if you look at the case made by MK, in paragraphs 46 to 55, it is a case without facts. It is pure abuse, bluster, and insult. There are no facts underpinning it. And it is pure argument, unfounded argument. And the President, in reply, addressed it firstly in paragraph 4, secondly in paragraph 46, and in the last place at page 001, page 630, I think at paragraph 48. But what he did was to say, I deny those allegations.
Paragraph, page 630, paragraph 40.
Let me just get it. But I don't have it for the moment. Can I come back to you on that paragraph?
I see it's got this 49.
I suspect so, yeah. Yes. So it's not as if the President didn't address it, but it was an accusation devoid of facts. It is a pure argument. And the President, in reply, treated it as such dismissed it and denied it. We submit with respect that there is nothing to the argument because it is not underpinned by any facts. It is pure vitriol, and for that reason should not warrant any serious attention. Thank you.
Thank you. Mr. Bukhari, you're up next. Yes, you can proceed.
My Lord and your ladyship, by way of introduction, the committee, that is the impeachment committee, was established by the Speaker in terms of the court order, which emanated from the Constitutional Court on the 8th of May, in particular paragraph 7 or order 7 of the judgment. The impeachment committee understands its duty to be one that is to be fulfilled independently, impartially, and without fear, favor, or prejudice. It is on that basis that it has decided not to engage with the merits at all because it has not gathered evidence, it has not yet made up its mind as to the guilt or otherwise of the president, nor has it at its disposal evidentiary material to take such a view. So the opposition to this application by the president arises from the impeachment committee's constitutional duty imposed on it by the Constitution and the Constitutional Court judgment. The committee has studied the judgment, and its understanding of the judgment is that the Constitutional Court has decided as a matter of finality that the Speaker must ensure that the judgment is given effect to, especially in relation to the referral of the independent panel's report to the impeachment committee. It elected its chairperson after it was constituted, and the chairperson has stated to this court under oath that he understands his responsibility to be one that must ensure that the proceedings before the impeachment committee are fair and transparent, and to protect the witnesses who may appear before it, if ever that will be the procedure that it will follow, that witnesses will come, including the president, not to be abused before it, and to protect even the integrity of the president. So the humiliation that the president is saying that he apprehends will be taken care of by the chairperson ensuring that nobody abuses the committee to advance personal or even inflict defamatory and unfounded statements against another person, including the president. So that point has been made clear by the chairperson under oath.
Just on that point, Mr. Bukhari, how is the chairperson going to protect the president against an unlawful report?
The chairperson,
If the report is to be found unlawful ultimately,
If
how
the
is
court-
the president? How is the chairperson currently? Say, for instance, the review court found that the report is unlawful. It should never have compiled in the fashion it did compile, and the conclusion was wrong, for whatever reason. how is the chairperson currently going to protect the president from that if the president walks in tomorrow to testify?
Oh, I understand the question. The protection by the chairperson is a process protection. It's not the substantive protection in terms of the evidentiary material. So it's to ensure that allegations are not made without being tested or without being supported. So he's talking about the protection of the president in relation to the material that is brought before the committee.
But that very
Not only
material
when-
relying that the committee is going to rely on, according to the president, is unlawful. How is that protection going to happen? Because obviously the committee members of the committee will use that information to question the president. What other information will they have in front of them?
Oh yes, obviously, I mean, the information that has to be presented before the committee must be evaluated, and if witnesses are called, then the witnesses must speak to the material.
Yes.
And so the protection is in respect of the process by which the committee will be following to ensure that every person who appears before it is given the necessary protection. So that's why I'm saying that it is the process protection. It doesn't extend to what happens if the review is successful or not. So we're not going there yet. So I'm just looking at what the committee has been mandated by the Constitutional Court to do, that once it starts at that stage, because at the moment it is busy with the preparatory stages. Once it reaches that step, the chairperson is informing this court what his duties are in relation to
No, I
the
accept
type
that.
of material.
I accept that, Mr. McCarver. What I'm just asking is, the chairperson came under oath and filed an affidavit how he will protect the president, not only the president, all the other witnesses that will testify in front of the committee, protect their dignity, that they will be dealt with fairly, and so forth and so on. But my question is a little bit different, is the committee will sit with a report to question the president. Now, how will he protect the president if the report is ultimately found to be unlawful? How will he be able to protect the president from now until the review?
Yes, my lord, remember that at this stage we are not talking about an unlawful report. We are talking about a pending review. I mean, Odekral, and our submission and our understanding of the Constitutional Court judgment is that that report has even gone past the stage of Odekral. It is a report that has been already sanctioned by the Constitutional Court to be evaluated by the impeachment committee. And I'm going to come to that point.
No, I hear what you're saying.
Demonstrate that point.
Yes. So if obviously then the report remains valid, which is correct position, then the point that made by Mr. Trengrove about the buffer, shouldn't the buffer then kick in and say, well, you can't protect me from that report, so therefore I need interim relief?
I'm going to address that point.
Yes, okay.
That was the next point that I was going to address by making reference to the judgment itself. Because, as I say, as a committee, we can only rely on what the judgment of the Constitutional Court instructs us to do and what our understanding are. And I'd like to turn to that point immediately. If the court can go to the judgment,
Yes.
and we look at the following paragraphs of the judgment, the court will recall that the president relies on paragraph 139 to assert that the Constitutional Court has left a window of opportunity for him to launch a review and challenge the
Yes.
report. But I'm going to demonstrate that isolating paragraph 139 from the earlier paragraphs is not helpful to the president at all, because arriving at 139, there was a build-up to that. If one takes it from, if we can take it from paragraph 135.
Yes.
You'll see in paragraph 135, and I'm looking at the main judgment by the Chief Justice. It says, The same concerns arise in this case. Rule 129I permits the National Assembly to terminate the impeachment process at a preliminary stage before a full inquiry can be conducted into whether a ground exists. This has the effect of foreclosing full engagement with the merits of the motion, thereby stifling informed debate and undermining the values of accountability and transparency that must inform the National Assembly's process. This is particularly problematic given the limited powers of the panel. As this court remarked in Oriani Ambrosini, such gatekeeping by the National Assembly constitutes the unconstitutional deployment of invincible giants as obstacles to the pursuit of constitutional ends, namely an impeachment motion being more fully and properly ventilated and scrutinized, and only thereafter decided upon by the National Assembly. So what, before I go to the next paragraph, what must be understood, and this is what the Constitutional Court was alive to, that the impeachment process, of course, is a constitutional imperative in Section 89 of the Constitution. But then the process itself, so you can't single out only one step in the entire chain and say that is the independent panel. The impeachment process, in essence, starts from the time when a member of parliament submits a motion, because that motion must prima facie set out the charges that must be preferred against the president. And the prima facie aspect is determined by the speaker, because the member submits the motion to the speaker must consider the motion, and when satisfied that it has that prima facie evidence of some kind of wrongdoing that requires an answer, then the speaker, then you go to the next step. But the process has already started, because the process is a Section 89 of the Constitution process. It's triggered by the motion that is submitted. And the president, of course, does not attack that first step, as I understand. The president takes no issue with the motion that was submitted by that member for the commencement of his impeachment. And that motion was submitted by the speaker to the independent panel that the speaker established. The president, again, did not take issue with that. But that's a very fundamental, important step. And I'm going to show to the court that if the president's approach to how impeachment process must happen is to be adopted, it will set a dangerous precedent, because it means that it will open a way where even other presidents that are still coming may simply stall this important constitutional accountability process. And by just singling one of the processes in the scheme of things and say that I'm taking this one and therefore you can't do anything until the entire court process has been finalized. Because if then one can attack the independent panel, how it did its work, then it is also permissible for one to even attack then the motion itself, the referral of a motion itself to the panel, and say that this motion did not establish a prima facie case. But it is simply the building blocks which end with the matter back to the National Assembly with the voting. So the next step then is, here is a motion. I'm now constituting an independent panel of 3 people, respected people, and what one has to now look at is, what is the role of this layer of the independent panel? Because that's where then the president has dedicated most of his attention, that this layer of independent panel, they have misconstrued their duties, and therefore they came with a report that is flawed. But that is a wrong approach altogether, because what one has to examine is, first, what is it that the independent panel is required to do? And of course, Mr. Trangov then was trying to make a distinction between a prima facie case and sufficiency of evidence. But I'm going to show to the court, even in respect of the rules themselves and the judgment of the Constitutional Court, that the prima facie and sufficient evidence is or are on each occasion understood in the context in which they are used in different parts of the judgment and also in different parts of the rules. But essentially one understands one thing, and the Constitutional Court also understood it that way, that whether you say prima facie, whether you say sufficient evidence, but you are actually referring to one simple thing. Is there a case to answer by the President? That's all what then you are asking for. Because the motion is then itself simply is a motion and with supporting documents there. Then you give it to the independent panel, which then asks itself a question. And they've done that in their report several times. They understood that is there sufficient evidence for a case for the President to answer. That's the thing. And
but what do you make of the argument by the President saying, well, you know, they've put a reverse onus on me. They didn't ask the right questions when they went through the evidence. And as a result of that, that is why I'm unhappy with the panel. Because the panel's report is the trigger for the Section 89 committee to be formed or established.
Well, he's mistaken there. That is mistaken for the following reason. The panel's duty is not to place onus on anyone. That's the first thing. So it's wrong on that one. The panel's duty is to look at the evidence on paper.
Yeah.
And of course, it does allow it to extend even to the President to say that, can you give us a version?
Yes.
But it's actually not even obliged sometimes. I mean, as long as then they have sufficient, but then at least that one they're allowed. But they're not allowed to go outside. So one has to understand what they come up with in the context of what the rules say they must have in front of them. It's not a full-blown trial like a court or like a tribunal or like a disciplinary hearing where then you can call for all sorts of evidence and making even some kind of subpoenas. It must be understood in that context. So there is no onus that is to be placed on anyone. So that is why their duty is not to make a decision. Their duty is simply to say that we have now looked at this material placed before us. We are satisfied that there is a case to answer by the President. And then that step is concluded, we move to the next step. So that's really all what it does. That's what all it does. Of course, Mr. Trangov is correct when he says that in order to reach the impeachment committee level, you need that committee to sit, consider the material before it, and submit a report. But in fact, when I come to the judgment itself, is fact in relation to the order of the Constitutional Court, you'll see that Rule 129I, which was amended by the Constitutional Court, it actually has gone further to say that even if the independent panel's report may find that there is no case to answer, the National Assembly may still refer it to the panel, to the committee, actually not panel, to the committee, to the impeachment committee. So that explains to you that the involvement of the independent panel is just one of the many steps in the impeachment process. That does not have to stall the process through judicial intervention. That's really then what it does. So that's why all the panel has to say is that we are satisfied on what is placed before us, that this evidence is sufficient or this evidence is prima facie. It doesn't matter then the terminology here. in the context of how these words are used. But as long as you are able to understand that what they're saying is that there is a case to answer by the president. And that's why then I was building up here to show that by the time the court arrives at paragraph 139, you have a clear understanding that the Constitutional Court was alive of what this independent panel report contains. It read the report and it understood that it is the kind of a report that the court can refer to the impeachment committee. It's not the speaker who referred it to the committee. The only duty that was left.
So you are suggesting that we must read into the paragraphs 135 to 139 that the Constitutional Court has already had sight of the report and made a determination that the report is good enough to be referred to the
Absolutely. I mean, let's look at 136, for example. In 136, it says, a rule allowing the National Assembly to thwart an impeachment motion at an early stage, despite a finding that the complaint is sufficiently substantiated, would fall foul of the Constitution for multiple reasons. It would, for example, and here, remember that it says, despite a finding that the complaint is sufficiently substantiated. The Constitutional Court was not writing in the abstract. It was writing looking at the actual report, an existing report.
No, but
So-
what the Constitutional Court is basically saying here, and I might be wrong, is they've taken away the National Assembly's right to be a further checked or box to tick off. That is what this paragraphs are saying.
That's my understanding. Yeah, that's my understanding.
Good.
So,
So how does that mean that the report is good enough to be referred to the impeachment committee?
Because
how do you make that leap?
Because sufficiently substantiated.
Yes.
Sufficiently substantiated. So that's why I'm saying that different words are used. Sufficient evidence, sufficiently substantiated, prima facie, but you are able to see at the end, when I conclude this part, that all what the Constitutional Court in the end is saying is that this report, did it come to the conclusion that there is a case to answer by the president, and it answered it in the affirmative. That yes, that's exactly what it does. Because then we say, then from there it gives examples there, and then at paragraph 137 it says, by imposing itself as a gatekeeper through Rule 129I, the National Assembly fails in its obligation to facilitate the impeachment inquiry when confronted with a sufficiently substantiated impeachment motion disclosing or yielding a case to answer. So remember here that the Constitutional Court is dealing with both the motion that was submitted by a member, which must disclose prima facie case, and the independent panel report.
But isn't the court speaking in general terms here?
No, it's
Does it
not.
refer specifically to the report of the panel?
No, it's not. Then you'll see when it develops. You'll see so it's not. It is speaking in relation to the report that is in front of it at the Constitutional Court. So the National Assembly must facilitate steps to be taken in this regard and the process to be followed, not only at the preliminary stage, but also at the stage of actual impeachment, up to the final stage of voting on whether the president should be removed from office, so as to determine whether the removal is supported by the necessary two-thirds majority. So the point that it is making here, it fortifies what I've said at the beginning, that the impeachment process starts with the motion. It's a section 89. Once then the motion is tabled, the impeachment process has started. And it goes to the next step, and what the Constitutional Court is saying is that that must proceed up to the last step. And what is the last step of impeachment process? Is the voting.
Yes.
And we know what is the outcome there. Either the voting will say that you have not secured a two-thirds majority, and therefore the impeachment process comes to an end with the president not being removed. Or the voting secures a 2/3 majority, the effect of which the president is removed. But it must ultimately come to that process. You can't hold it midway. You can't hold it midway.
No,
Then-
but I mean, I hear what you're saying, but the difficulty with your argument is this: you can't hold it midway. If that is what the judgment says, which I think I might disagree with you, because why would the Chief Justice then say unless and until the report's being set aside on review? Why would she mention that if the process cannot be stopped?
Yeah, no, I understand that. So I am building up to that. I am building up to that point. So that one understands it in the context of the impeachment process on its own. Remember that the impeachment process is a constitutional duty. It is something that is triggered by the Constitution, Section 89, and the rules must create a process, and that process, once started, it must be seen to the end. Of course, then, maybe then to come in to answer that question, I would then say, for instance, or then over Justice Francis then said when he was engaging Mr. Trengoff, or I think it was you, Justice Lefranc, to say that, well, let's say then the report, you put it aside, but the process then doesn't end, because you can simply then you simply constitute the same committee or another committee. Because then that process of the impeachment, of the independent panel, it doesn't erase the motion. The motion still exists. You see, the charges don't go away because of you are attacking the independent panel process. So that's why I'm saying that at the end, you have to come to the end of it, and that's what this paragraph 137 is seeking to convey. And the end result is that there must be a voting before the National Assembly. So 138 says, it is not sufficient for purposes of the obligation to take appropriate action for the National Assembly to proceed directly from receipt of the report to a vote and thereby suppress an impeachment motion that discloses prima facie the existence of a ground under Section 89(1). I remember I started by saying that the motion itself has not been attacked by the president. So the motion is still there and still stands. And so what the Constitutional Court was dealing with here, it was how the National Assembly suppressed it initially when it actually just halted the process there without referring it to the impeachment committee. Then the Constitutional Court simply says that you have jumped a very important step. And I'm going to come to what is the importance of the work that is done by the impeachment committee, because it does a very fundamentally important role, because it is the actual investigative stage there. So where now you gather evidence and you even formulate your own rules of procedure, how you're going to go about, whether you're going to call witnesses or you're not going to call witnesses, and so on. So you have the latitude to come with mechanisms that you must put in place to ensure that you fulfill that constitutional obligation, because it is your report that is going to be a trigger to the voting by the members, whether to achieve a 2/3 majority or not. So then that is what the Constitutional Court is saying, that you can't jump such an important constitutional step. That is, that the National Assembly is required to do more than have a substantiated motion merely tabled and debated and voted on. There must be an inquiry of some proportion or other into impeachment motions that are not plainly unmeritorious. So there must be an inquiry of some proportion or other into impeachment motions that are not plainly unmeritorious. And that's important. It is the motion that matters. So it is the motion that will be unmeritorious, not the independent panel report. The independent panel report will know what their function is. It's a very limited function, which sift that and look at that motion with whatever is before it and submit a report to the Speaker. But what should not be allowed is unmeritorious motion, and it is the motion that is submitted by a member, and that's very important. And it says, and there must be a determination as to whether the president has breached section 89, 1A and B of the Constitution, or in terms of section 89, 1C, is unable to perform the functions of their office. So that's what the Constitutional Court is saying. Ultimately, there must be determination on that issue.
Yes, but the Constitutional Court also said, as you highlighted in paragraph 139, the following, and I quote, "There need not be a full-blown, exhaustive inquiry into every single impeachment motion that survives an initial sitting."
Sifting.
Oh, sorry, sifting.
Yes.
My glasses.
Yeah, sifting. Yes, it's true. It's true.
Yeah.
Then that's what it says. So,
Yeah.
so
But
it's
it
not a
goes further.
full-blown thing.
However, where the panel, like in this instance, concludes that sufficient evidence exists to disclose a prima facie case, its recommendation that a Section 9 inquiry be proceeded with, and this is very important,
Yeah.
must be implemented through a referral to an impeachment committee.
Yes.
That has happened.
Yes, and that has happened. Yes, it has happened.
And now here's the
And so, comma, there's a comma there.
unless and until the report is set aside on review.
Yes.
Now, this is what the president wants to do. And
Oh.
this is part A of the review.
No. Then it's a complete misunderstanding of what
Oh.
the judgment is saying. It's a complete misunderstanding of what the judgment is saying. The judgment is simply stating the well-known legal requirement that if you are not happy with an administrative action, you take it on review. It simply states a general proposition that when you are not happy with an administrative action, you take it on review. But this report, it didn't say to the president that you are entitled to take this report on review.
But
this
this report are they talking about here in paragraph 39?
That just say it in general terms. But this report, they've referred it to the impeachment committee already. So that's why I'm saying that it would be incorrect to read this sentence in paragraph 139 to mean that the Constitutional Court has granted the president leave to take the report on judicial review, because it wouldn't make sense for the same court to have referred it to the impeachment committee, because it was still perfectly entitled to say that, well, because this report has not yet been determined by the court its validity or otherwise, we are simply going to stop at declaring Rule 139I unconstitutional and reading into that rule, and then the National Assembly must see what to do with it. But it didn't do that. It didn't do that at all.
Where I'm sitting from, I'm differing from you, from your propositions that he's making. Because if we read here, however, comma, where the panel, now which panel are they referring to?
It's an independent panel in general terms. Remember that the independent panel.
No, but we're
is
talking
not-
about
it's not-
the impeachment.
No, I'm saying.
If you look in paragraph 138, it talks about section 89 1C is unable to perform the functions of the office. And then it goes, there need not be a full-blown exhaustive inquiry into every single impeachment motion. That's the impeachment motion you're referring to.
That
That survives an initial sifting, full stop. However, comma, where the panel concludes that sufficient evidence exists, and it can only be the panel that we are debating about its report, to disclose a prima facie case, its recommendation that the Section 89 inquiry, and Section 918 inquiry refers to that of the President, be proceeded with, must be implemented through a referral to an impeachment committee.
Yes.
The committee, the chair you are representing,
Yes.
unless and until the report is set aside on review.
Yes. No, you're right there.
Yes.
And
So
where
we are now
differ-
in part A of that review.
Yeah, no, you're right. Then that's what I'm saying, that where we differ, where we differ is when then your Lordship says that this paragraph, which says unless and until the report is set aside on review,
Yes.
it applies to this report. So I'm saying that that is a general proposition, because the report in paragraph 7 of the order has already been referred to the impeachment committee. Otherwise, it wouldn't make sense, because one has to read the judgment as a whole in order to understand the order that the court arrived at. And especially if we take it a little further and we don't stop at 139, but we still go to 140 and 141, and of course, your Lordship did refer, Mr. Trengov, to 141, but 140 there, it says, it may be that the evidentiary basis underpinning such a motion, despite being found prima facie, substantial and credible by the independent sifting mechanism, currently the panel. So then here, you see, then the Constitutional Court makes it clear that he's talking about this panel, cannot survive initial scrutiny by the inquiry, currently the impeachment committee. So then where it is talking now about the existing panel or the panel that looked at the motion, it does so, and the current impeachment committee, then it does so. So one is able to understand, and where it says, it simply sets the legal principles in general terms, then one must understand it that way. And then it says, once seized with the manner, the impeachment committee performs a distinct investigative function and subject to the National Assembly rules, particularly Rule 129M, retains control over its own proceedings and the scope of its inquiry. It may therefore become apparent, even at an early stage, that the evidentiary foundation underpinning the charges cannot sustain a finding that the alleged conduct will be established. So here you can see that even the Constitutional Court was using sufficient evidence, prima facie, interchangeably, and you are going to see when I refer the court to the paragraphs in the panel report itself, that it was alive to sufficiency of evidence, prima facie, and it explained how it understood its function to be, that at the end of the day is to establish whether there is a case to answer by the president. And once then it has
Can I
done
ask
so.
you a question differently, Mr. Mukari? If there is a impeachment motion before the Speaker, then the Speaker, if your CC finds that there is prima facie evidence or information or whatever you want to call it,
Yes.
it refers it to the panel.
Yes.
The panel compile a report. Now, in terms of the new rules after the Constitutional Court case, that report is given to the Speaker, isn't it? And the
Yes.
Speaker must then compile a committee, impeachment committee.
Yes.
Now, in the ordinary course of events, how will that happen in practice? So, the Speaker receives an impeachment motion. She refers that motion to the panel. The panel compile a report, and the report gets handed over to the impeachment
Or impeachment.
impeachment
Yes,
committee.
yes.
So that is the flow of events that is currently prescribed by case law and also the rules, if I understand it correctly.
You're correct.
Now, what is the Chief Justice talking about unless this report is set aside on review? When does that kick in?
Well, there's a general legal proposition that is well known.
Yeah,
that's how you upset a report.
Yeah, but
which is
in this
subject-
instance here, how will whoever is not happy with that report, how would he or she come to court?
Well, let's
Because
say,
the report is now ready with the impeachment committee.
yes, and referred by the court. So,
No. In the ordinary course of business, never
I
mind.
see. Oh, I see. Yes. So, in fact, things developed that way from the beginning. If we can just go back a little bit,
Yes.
you'll recall that after this independent panel submitted its report to the Speaker,
Yes.
then a vote took place.
No, I know that
Yes.
that can no longer happen.
No,
The Speaker must now refer it to the
Yeah, I
impeachment
understand
committee.
that. I'm just building to that because I
Oh.
understand your question very well.
Okay.
So then after that, what ought to have happened? What ought to have happened at that stage? Should the Speaker have referred the report to the independent panel, then the president was perfectly entitled to take it on review, which he did, actually. Which he did.
Now, what
So,
did- what
and,
did-
and the reason why I'm saying so is because at that stage, the report has not served before court and considered by the court, and the court making an order referring it to the impeachment committee.
Now, leave this report out for a moment, just in the ordinary course of events.
Okay.
There is now today a motion of impeachment before the Speaker. How should that develop?
Yes, oh, no, I understand. So it's going to be exactly the same way. So there is a motion, and then it goes to the independent panel.
Yes?
It prepares a report, it submits it to the Speaker constitutes an impeachment committee.
And
But
that-
in the process of that, the President can, at any stage there, take it on review, because the report has not been the subject of a court order. He can at that stage. So it will follow that it's exactly then what happened, but the only thing what happened is that the President then withdrew his review application.
No, just leave the President in this case out. I just want to think and ask this. So if the Speaker hands over the report to the impeachment committee, whoever feels aggrieved by the report, according to your submission,
Yeah.
cannot now come for a review of that report because
No, I'm
the
not saying
impeachment
that.
has already got it.
No, I'm not saying that. Because the Speaker, then the Speaker is just one of the functionaries in the scheme of things whose decisions or actions are susceptible to review. So there I'm not saying that. I'm saying that in a situation where the report has already been the subject of a court order, and the court itself, not the Speaker, has referred it to the impeachment committee. So these are two distinct situations. So first, you have a situation where the report has not been subjected to the scrutiny of the court. The Speaker is referring it to the impeachment committee. That is a decision of a functionary which is susceptible to review. It can be, whether under legality or whatever. That you can do. So here I'm saying that the President has missed the boat. That's the point that I'm saying. He has missed the boat because this report was in front of the Constitutional Court to be scrutinized and looked at by the Constitutional Court. The Constitutional Court, rightly or wrongly, made an order. Section 165(5) is very clear. Whether then you are happy or unhappy with the order, it remains an order. Unless if the proposition is that of all the orders in paragraph 1 to 8 or 1 to 8, then only paragraph 7 does not constitute an order. But paragraph 7 carries the same weight as any other order that was given. And that order is very specific. It's referred to the impeachment committee. It is not the Speaker who referred this report to the impeachment committee. It is the court itself which referred. The only thing that the Speaker did was to constitute a committee in compliance with the court order. And she had to do that because we live in a constitutional democracy where we must respect the rule of law and the court orders. And the President himself is one of those people who actually is the first citizen, must be the one who must lead by example. He's the one who must be able to say that I'm going to ensure that this order of the Constitutional Court, which is the highest court in the land, is respected, and I'm going to support, like organs of state must support and must ensure that they protect the dignity of the courts. They will say that I am actually leading by example by making sure that I'm going to support the work of the impeachment committee established by the Speaker, and I'm going to avail myself whenever they need
I've
me
got no
in order
difficulty
to
with
place this into
your
rest.
argument. My only difficulty is that the apex court would have pronounced on the report itself and make a finding that the President cannot challenge the report.
But it didn't have to make that finding. It didn't have to make that finding.
No, but
The report itself is referred. So it didn't have to make the finding.
yes, it referred the report to the impeachment committee,
Yes.
but it allows whoever is unhappy with that report to bring a review application. You saying no, it can't be. That's my only difficulty that I've got.
Yeah, but my lord,
May I ask you a question, Mr. Bakari? It seems to me your argument is predicated on the idea that the Constitutional Court has closed the door on challenging this report. And you say that because you say paragraph 7 of the order says it must go to the impeachment committee. But are we not to interpret the orders of the court in the light of the judgment as a whole and in the light of the questions which serve before the court? You know the position with stare decisis. What is the ratio of the decision? And it seems to me that the ratio of the decision in the Phala Phala judgment, what the court was grappling with was that the National Assembly couldn't close the door. And that was the context within which we must interpret the court's order. It didn't ask the question that the review court is going to have to answer. Not so.
No, you're absolutely correct, Justice Davis.
And if it didn't ask itself that question, and if that was not what it was grappling with, surely it can't have definitively pronounced on it. That's what the review court is going to have to do.
Well, you're correct on the first part, then Justice Davis, that that issue was not before the Constitutional Court. It didn't have to pronounce on it because it was not before it. It can't pronounce on that. But what we have to look at is the order itself read together with the reasons for the judgment. So the finding, and it's not a finding here, because to me then this is simply what we call an obiter. It's not a finding. This line in paragraph 139 is not a finding of the court. It's simply an obiter. But the point I'm making is that if that was such a finding, one would have gotten it then in the orders themselves, because it's an important one. So that the court can explain how did it refer a report that is still susceptible to review, or may be susceptible to review, to the impeachment committee. But let's put it then differently and say that. Let's say then we accept the proposition that indeed, because the Constitutional Court has said in paragraph 139 that a report of the independent panel may be taken on review and therefore the President has done so. You still have to read that together with paragraph 7, which means that as the impeachment committee, we have to comply with the order of the Constitutional Court by making sure that we proceed with our work. And the President can continue then to review the report, and whatever outcome comes there is never going to change the fact that the Constitutional Court has said that the impeachment committee must do its work, and its work is that it must investigate and submit a report to the Speaker for a voting, so that that entire process, which started with the notice of motion submitted by the member of Parliament, is now brought to conclusion with a vote. So that will still happen because the court order must still be complied with. Otherwise, it will be to make a mockery of the stare decisis principle, that you have a high court which then is going to interpret the Constitutional Court orders in a manner that undermines the very orders that the Constitutional Court has granted in order to give finality to an important matter such as this, especially taking into account Section 237 of the Constitution. Constitutional obligations must be performed immediately without undue delay. So how does it help the Republic of South Africa that a motion that was initiated by a member in terms of Section 89 of the Constitution is halted through judicial process, despite that constitutional obligation is to be performed to finality, and the President is never held to account at any stage, given that a President is not somebody employed indefinitely or for life. Is somebody then who is elected for a specific duration of 5 years. Those are the factors that the Constitutional Court has taken into account to come with such an extraordinary order. I accept it's an extraordinary order, actually. It's quite extraordinary. And I want this bench to ask itself that question. Why did the Constitutional Court make this extraordinary order in paragraph 7 of the order? Because it has concluded that this report must be processed as a matter of great importance, and then you have seen in the preamble, paragraph 1 of the judgment of the Chief Justice, this is a matter of grave public importance. But then when we are now engaging on litigation which seeks to undermine that very order, then we are really what message are we sending to the nation? That court orders can simply be disobeyed, or we can come with some kind of innovations and technical legal niceties not to give effect to them. Because these are not only our orders, these are the orders of the nation, of ordinary people who are sitting there, who want to see that this constitution is alive and it can actually take us forward, not backward. So I'm saying that as a committee, we are going not outside what the Constitutional Court has said. We are keeping ourselves within what the Constitutional Court has said to us, and that you have a report in front of you, process it, and then the President says that High Court interdict them. They mustn't process it. I don't know then what the court is going to do, especially in the light of the jurisdiction point that we have raised, because, well, there is already the Zuma judgment in the KZN. So either this court then must differ with it or not, but there is a precedence on that issue that you can't interdict.
What relevance is that Zuma judgment to this matter?
Well, I think the message, I think the essence of it is simply to say that when there is an order which already compels or requires you to do something, that order can only be stayed or maybe rescinded by that very same court. So we say that it is a constitutional court order. If the president wants to stay it because it's prejudicial to him, he must go to the constitutional court. And that's the court that will be able to entertain him because it has the power to do so.
In that matter, it was the Constitutional Court
Yeah.
that made the order.
It was the constitutional court that made the
That's
order.
not the case here. Constitutional Court, as I understand it, didn't rule on the report per se. It dealt with some other issue.
You mean in the Zuma matter?
So in the matter presently before us.
No, what I'm
Court
saying, what I'm saying is that the president wants to stay paragraph 7 of the constitutional order. He doesn't say so in the notice of motion. He doesn't have to say so in the notice of motion. That is the effect of it. I'm talking about the effect. So I'm saying that it is an order of the constitutional court which the president wants to stay, because this inquiry, it was never going to be established if it was not for this judgment. They were never going to be sitting here and dealing with this issue. Because as Mr. Trankov said in his of arguments that it was 3.5 years ago, we were never going to be. Actually, the president's term was going to come and go, and was going to leave without anything. But this is a trigger. The Constitutional Court then has actually brought us now back to our constitutional duties to say that Parliament, you have a constitutional obligation to hold your own president to account. And you must do so and do so immediately. And that's what they're saying to us.
You've got 2 minutes, Mr. Mukari.
Then to use my 2 minutes fruitfully, I would like to just make then the court to note the following. Well, I just want to just briefly to deal with the issue of sufficiency of evidence prima facie to show that the understanding of the committee in line with the Constitutional Court order is that those terms were used interchangeably. In fact, Mr. Trankov was also using them interchangeably. Because I mean, that's the only way you can use them in the context here. So in the report itself, I'm just bringing the court to the following paragraphs, which will simply note where the court, I mean the independent panel, has used the word sufficient evidence 11 times. 11 times. And to show that it properly understood its duty and responsibilities. So it is paragraph 3, paragraph 4, paragraph 48, paragraph 51, paragraph 67, paragraph 72, paragraph 75, 76, 99, 125, and 126.
120?
126. So it's to show the appreciation by the panel of what its responsibilities were. And that really then doesn't tie up with what the president said, that they simply did not understand that. And prima facie, and you're going to see the context in which they used prima facie in the report, and they used it 18 times. But they used prima facie only in relation to the motion that was submitted to the speaker. So this notion by the president that they simply do not understand what is the sufficiency of evidence and prima facie is simply not borne by the very report itself. So we submit that we have studied the judgment, we understood the order, and as the impeachment committee, it understood that it has to continue with its work, and its work is to ensure that it gathers the evidence, it sets out then the processes, terms of reference which will guide it, but the ultimate outcome must be transparently, openly, fairly. It must determine whether the president has committed the transgressions which are set out in the notice that was submitted by a member of parliament and submitted to the National Assembly for a voting. And that's the function that this court cannot stop. Oh yes, oh, of course. I mean, like paragraph 139 is my junior of the judgment, that the Constitutional Court also understood it that way. You'll see there, where Justice Lecrant was reading that there need not be a full-blown exhaustive inquiry. The third line at the bottom there, you see there, it says where the panel concludes that sufficient evidence exists to disclose a prima facie case. And that's what they're saying, and I don't know what are we arguing about then. I mean, really, then the president, it's just a question of semantics on such an important matter. So I'm going to leave then arguments regarding prima facie evidence in respect of the interim interdict, the balance of convenience and alternative remedy to other members then of the respondents, because I've seen that they've dealt with it, and I don't want that each one of us then should repeat the same thing.
Thank you, Mr.
So then there's no need for me to do that. So basically then, as the committee, you have seen that we did not even take issue of urgency, because we simply say that, well, whilst then our view is that the matter is not urgent, but to us as a constitutional duty that we have to perform, is of profound importance that we know exactly where we stand and we know what things then are happening or things are not happening. But insofar as the order that now it must be tailored to no longer read the way it is in the notice of motion, it must now say that interdict the public, the public hearings. Well, that is really a substantial amendment, not of a notice of motion, but even of the affidavit itself, because it doesn't make out that case. This is borne by what we have said, to say that we have already started the work, because the process and the work starts the moment then we were elected, and we were appointed, and then we elected the chairperson, and we started with preparatory work. That is actually then the impeachment work, which we are busy with, and so it can't be interdicted. So then we say that the interdict then cannot succeed on those bases, and you have seen that we didn't really make much then of the cost, but it is our submission that in such a case as this, the president is litigating as the person of the president, and a cost should follow the event. And in this case, then it's cost of threat counsel. It's an important matter. It does warrant a threat counsel.
Thank you, Mr. McCoy.
As a court business.
Thank you.
Mr. Katz?
Thank you, my lords, my lady. I, on behalf of Mr. Zangula and the ATN, wish to hand up a bundle of our authorities, which I want to turn to in the first instance. And I want to suggest that by starting, this application asks for extraordinary relief. And not only that, it hasn't even got off the ground in making a case out for ordinary relief. And I'll explain why. And the three pillars that I'm going to come to in rooting my argument are these. And we have a good foundation. Our foundation are these three pillars. One, this court will look at the pleadings. And for that proposition, there is a case, an extract from a case, which I've just handed in. It's from a constitutional court case called Garvis. It's Atawu versus Garvis, paragraph 114. Chapter J says, holding parties to pleadings is not pedantry. It is an integral part of the principle of legal certainty, which is an element of the rule of law, one of the values on which our Constitution is founded. So what we would ask the court to do is to look at what the President says in his affidavit. And when you look at what he says and what I will forensically analyze, I will demonstrate that he hasn't made out a case. Leave aside what the respondents say. He hasn't made out a case not only for ordinary interdict relief, but even for extraordinary relief. That's proposition number one. Proposition number two is what the President is trying to do is to ask this court to traverse the lane of another organ of state or another branch of government, which this court will not do unless special extraordinary circumstances call for it. And for that proposition, I'm going to turn to I think it's the third judgment in my bundle, and I'm going to ask the court to turn to page 87, paginated of the bundle.
80?
87. And in referring to paragraph 93 of the judgment, I said to my junior, Mr. Puramalsamy, I feel like I'm in a movie. Because this
looking
judgment...
at all these cameras, it looks like it.
Yes, but the movie... Well, let me talk about the name of the movie. The name of the movie is Nkandla to Palapala, the saga continues. And four of us, that's Makari, Mpofu, Trengrove, and I, are veterans of this saga. And this is what happened. The Chief Justice in Nkandla says to this court what this court should do. And may I read it? It falls outside the parameters of judicial authority.
No, sorry, where are you?
Paragraph 80, page 87, paragraph 93. Paragraph 93.
Oh, okay.
It's on case lines, it's on court online, but I thought I'd make it easier for the
That's
hard.
page 89, according to us.
No, page 87.
We've got it as 89.
Oh, case line's 89, the
Yeah.
hard. This is the hard copy that I've just handed up.
Yeah.
The top right is 87.
Oh, I see. It's just...
So it's paginated. The pagination for my junior's computer is 87.
Okay.
So paragraph 93 says, it falls outside the parameters of judicial authority, that's this court, to prescribe to the National Assembly, and we emphasize, how to scrutinize executive action, what mechanisms to establish, and which mandate to give it for the purpose of holding the executive accountable and fulfilling its oversight role of the executive or organs of state in general. The mechanics of how to go about fulfilling those constitutional obligations is a discretionary matter, best left to the National Assembly. Ours, the courts, is a much broader and less intrusive role, and that is to determine whether the National Assembly, what the National Assembly does in substance, and I'll come to Justice Francis, your question about the question of the panel report and the question of whether or not the wrong test had the wrong conclusion, and Mr. Trengrove made what I would call a concession this morning, which is destructive of his entire case, on the question of the validity of the report. So I flag that. And in reality amount to fulfillment of its constitutional obligation. That is the sum total of the constitutionally permissible judicial inquiry to embark on. And these are some of the vital limits of judicial authority, and the Constitution is designed to leave certain matters to other branches of government. Courts should not interfere in the processes, and we emphasize processes. This is a process disturbance. And I'm not talking about the review. I'm talking about what's going on today. They're trying to stop a process.
But it's part of the review.
No, it's
part
not.
of the review.
I'll come to that, my lord. I'll
Okay.
come to that. But it's not. This is not the review. This is a disturbance of a process that is unfolding. And I'll come to the questions of interim relief pending a review. Because if you're right, my lord, then you might as well do the review today. There's no review before this court today. There is a process disturbance, interference with a process. That's what you're here today to decide. It is therefore not for this court to prescribe to Parliament what structures or measures to establish, to employ respectively in order to fulfill. The last sentence. Then it says courts ought not to blink at the thought of asserting their authority whenever it is constitutionally permissible to do so, irrespective of issues. And then it says here, at the same time and mindful of the vital strictures of their powers, they, your lordships and her ladyship, must be on high alert against impermissible encroachment on the powers of the other arms of government. And I have a note here.
But sorry, the Constitutional Court said that in the latest judgment of Economic Freedom Front.
This is Economic Freedom Front.
No, this is the EFF versus Speaker Magwings said
Yes,
that.
this is it, yes.
But the current Chief
Yes.
Justice also said
I'm coming to that.
Paragraph 151.
I'm coming to that one.
Okay.
Now,
She said the same thing.
okay, but I'm emphasizing. And
Okay.
but what I want to say is this. On the pleadings today, no, it's slightly different. No, I want to make this point.
No. She said it.
Yes, no, but I want to make a different point
Oh,
in
okay.
context.
You can make a different point.
What the President is trying to do is to interfere in the processes of the Parliament today. Review court, it's a different debate, which I'll come to. In interfering with asking this court to interfere with the processes, there's a number of features that must play a role. One, does he in any way suggest that Parliament's exercise of discretion to continue or not to continue with the inquiry pending the review was unconstitutional? No. That's important. Let me repeat that. He brings his review and then he says, I didn't expect Parliament to continue. I assumed they'd stop. I brought a review. What's wrong with this Parliament? Parliament says we're continuing. And there's a whole issue of urgency, etc. He brings his interdict, and in his interdict, and I'll turn to it, he does not say that Parliament's exercise of discretion to continue despite the review was in any way unconstitutional. That's the end of his case. You will not find on the pleadings any suggestion by the President that when Parliament decided to continue its processes, they acted impermissibly. He doesn't like it. He talks about humiliation, defamation, all those things, but he doesn't critique, there's no review of Parliament's decision to continue. There's no suggestion in his papers that that was an unlawful decision to continue. It continues because that's what is in the lane and the realm of Parliament. And this court should be on high alert not to cut into that lane.
But if you with regard to the factual matrix of this case, here, as Mr. Bukhari has pointed out, the Constitutional Court referred the report to the committee. Now, how can the President complain about that? There was no discretionary powers given to the Speaker.
No. So maybe
The court said, here's the report, it goes to the committee. That's the point that they
Yes.
made. So there was no discretionary powers that the President can complain about.
I'm making a different point, Justice.
Oh.
When the President brought his review,
Yes.
he then wrote, I think he wrote to the Speaker, and he said to the Speaker, please hold off on continuing. And he wrote to the Impeachment Committee saying, hold off on continuing until the review's finalized. Your Lordship will recall that from the papers.
Yes.
And what did the Speaker and the Impeachment Committee decide? I think together or in some way or other, they looked and they said, we've looked at your review. We have a constitutional obligation to do what we've got to do under 237 of the Constitution in a particular way. We are continuing. He then brings his interdict. So when your Lordship points to paragraph 7 of the Constitutional Court judgment, it's got nothing to do with the point that I'm now making, with respect. It's a different point. Parliament could have said to the Speaker, could have said to the President, oh, we've looked at your review. We hear that you've got a review coming up in September. We'll stop. Or we'll continue our preparatory work. We won't call witnesses. We won't call you. They could have said that, but they chose not to. And when they made that choice, that's their process. It was for them to decide, and there's no suggestion that that decision was in any way unlawful or unconstitutional. That's the point. They had a discretion. They could have stopped. And then my client might have gone to court to say, hey, how can you stop? But they chose not to stop. They chose not to hold the thing in abeyance. That was their decision. It was their lane. They made that decision, and there's no suggestion by anybody ever, not by the President, not by his counsel in argument, that that decision was a bad decision. That this court will, in the circumstances, not interfere with that decision. That's my second foundation.
But let's just engage on that argument of yours. So you are saying that because the Speaker said fine, we're not going to engage here. We leave it up to the chairperson of the impeachment committee. Therefore, that decision by the Speaker has not been challenged. And therefore, because it hasn't been challenged, the President cannot now come cry foul here.
And the decision of the chairperson. Both of them. They both made the decision. Well, both. The Speaker passes the torch, if I call it. I don't say the mic. The torch to the chairperson of the committee. The committee have a debate on TV, and they decide, no, we're not going to stop. We're going to continue. The President doesn't challenge that decision. Never. Look at his pleadings. You will not find any word that anybody in Parliament, whether it's the impeachment committee or anybody else, did anything wrong in deciding to continue the process.
But why should he challenge that if you want to have regard to the judgment of the Concord that says that report remains unless and until set aside? So what?
No, he doesn't have to challenge it. But the point I'm making is this. When Parliament decide on a process such as continuing,
Yes.
this court will not interfere in that process at all unless it is suggested that the process chosen was unlawful, unconstitutional. And there's no suggestion of that. So he is asking this court to interfere in a process which is not unlawful. Justice Surrender, I hope I've answered the...
No, you've answered.
Whether you like my answer or not is another, but that's the end of the case.
Mr. Katz, you know me for a long time.
I've known each other for them.
I'm sitting here with an open mind.
As it pleases the court. I expect nothing more, nothing less, and
Absolutely.
hopefully your mind will be filled with our argument rather than some. Now, my lord, the third, and my lords of our lady, my third leg, which is somewhat allied to the first two legs, is what is actually going on here. And one looks at what we say, and we looks at what the President says, and there's a disconnect in this sense. What's actually going on here is an application, and I've made my point in my second foundation. My third foundation is what's actually going on here is an application for an interim interdict, which has the usual requirements. We all know what they are. I think I pronounce it Setlogela. Mr. Kasiboto told me that's the wrong pronunciation. Together with OTA. That's what interim interdicts are for. Courts throughout this country deal with Setlogela every single day. But here's an extraordinary Setlogela application because it asks for an organ of state which is exercising its constitutional mandate to hold off. And the Constitutional Court in OTA has said, don't do that. Now the President responds, it cuts both ways, because he, if you read paragraph 1 of his heads, which I asked, may I take the court to the President's heads, paragraph 1, because we find this unfortunate. He says,
No, just give me a second to get there.
What he effectively says is that OTA, in this case, cuts both ways. It certainly doesn't. It cuts one way, and the way is our way, not the President's way. And the reason we say that is because in no way is the President's ability or his authority to exercise his executive mandate compromised one way or the other by the impeachment committee continuing and by this court not granting an interdict at all. So there is no others, there's no cutting both ways, it's one way, which is that this court would be interfering with Parliament's business, not interfering, if it doesn't grant the interdict, with the President's business. There's no suggestion that the President can't conduct his, or he's not in a position to conduct his executive authority were the interdict not to be granted. There is not a suggestion. So I want to turn to the pleadings. Sorry, but before I just jump off, I just want to highlight an issue.
No, you're referring us to his heads of argument, paragraph 1.
Oh, sorry, yes. No, I was just
No,
making the
going to
point.
the
So this is a similar step. Sorry, this is what is this case about? The president says it is another step in a long-running attempt by the president's political adversary to remove him from office. The attempts came to naught, but 3.5 years later, attempt was, etc. It held the National Assembly rule, the Constitutional Court replaced. You look, we've had the debate for the last 2 hours. But then he goes on, and he says in paragraph 3, you've heard the argument, this application is more modest. And he says that merely ask for a stay until the court is determined. This has been set down for September. Then he says, and you heard Mr. Trengrove say it this morning, the president, in other words, merely asked for a stay of a few months. Now it's uncontested on the ATM, Mr. Zungulu's evidence, that that is not so. Because in terms, the parliamentary timetable is set out. There's an election, a local government election, I think it's the 4th of November. Parliamentarians go on leave to go and canvass for votes in the October month. The effect of this order would be to postpone any continuation of, and I use the word continuation where I'm going to come to another point, of the impeachment committee to sometime next year after SONA. And then there's the budget speech. And there's all these things. So a mere modest 4 months on any basis turns into maybe the second quarter of next year. Maybe. So we must be very careful when it comes to the evidence to focus on what are the true few months modest application. This is effectively a long postponement, bearing in mind that we're in the middle of July. The National Assembly's power to remove is derived from Section 89. The procedure is regulated by the National Assembly, the history, etc. But the proposition that I wanted to make is those paragraphs in the introduction say that OTA cuts both ways. It doesn't. That's what I want to ask the court to accept. That's my third foundation. So I want to just turn back to the bundle, the main bundle. The court will see that there are 11 items. The first item is the Pala decision. I'm not going to refer to it. It seems that the court is well versed in the intricacies of the judgment. The second item is the Nkandla decision.
Sorry, are you talking
This
about...
is the covering page. I'm just going to do the covering page
your-
of my my bundle of authorities.
Oh, bundle of authorities.
The cover page, the index page. Do you have a hard copy? No.
Yes,
So the first item is the Pala decision, Constitutional Court. The second item is Nkandla.
Yes.
And importantly, the third and fourth items are judgments of full benches of this court. The first is judgment of Saldana J with 2 others concurring, and the second judgment, that's the fourth item, is a judgment of Erasmus Villa and Delamo as a court. And they both deal with interim interdicts, pending what? And about what? They were interdicting impeachment proceedings of the then public protector. And we ask that unless this court finds that both judges are absolutely wrong, on the pleadings, the president has made out no case for irreparable harm. And you don't have to get into balance of convenience prima facie law. On the pleadings, and I'll turn to the pleadings right now. So in the pleadings, he tells the court why he's here in paragraph 14. He says to the court in paragraph 14, on page 11 of the case line bundle, why am I here? Why are you here? Why are we here? Why are people watching on TV? And he tells the court, this is what he says. The purpose of this application is thus to preserve the status quo, and here's the important words, by the president, and to protect the integrity of the pending review proceedings so that the review court may grant what? Effective relief should it set aside the report. Let me emphasize. On the pleadings, that's what he tells the court he's here. To do what? Protect the integrity of the review. And let me say up front, if this court does not grant the interdict, there can be no suggestion, and there isn't one, that the integrity of the review will be compromised. There isn't a suggestion, as there can't be.
If
It's
we don't
not what-
grant the interdict,
Excuse me?
if we don't
If
grant
you don't grant the interdict,
Yes.
then in September, nobody can suggest that the integrity of that process would be compromised, the effectiveness of it. It's not like-
I think what Mr. Kengo is saying is that if you don't put it onto it now, and the cameras roll and the president is interrogated up here and down there, does it actually matter what the review court says? The only thing to be done, as I understand it, that's to be said.
Yeah, can I unpack that in two ways? What damage? It's not a deportation case where there's a stay of a deportation pending a review of the deportation. Because if the man or woman is deported pending the review, then the damage is done. So he can't argue that the review becomes nugatory. He doesn't, and he can't. So what is the damage? Your ladyship put to me the damage would be done, but what damage? And this is why I turn to the two
Well,
cases.
the damage could be that the people are using a report that's currently lawful that will amount to be unlawful if the review court decides that, to question him.
Yes.
So they're using unlawful
Yes.
methods to question him. That's the damage.
That's not irreparable harm per the two full bench decisions. That's the point that I'm driving at. So if he appears and they ask him questions and he answers, leave aside whether he exonerates himself or he incriminates himself. The question of appearing and answering questions has been decided by this court in two cases, both full benches. That isn't irreparable harm for the purposes of an interim interdict. That's why I mentioned items 3 and 4 of our bundle. That's point number one. And perhaps I should take the court to it. Because they say, Advocate Mkubani says, the damage will be done when I have to go to court, when I have to go to Parliament and answer questions.
What are we to make of the different contexts, though? Advocate Mkubani, as I understand it, was facing allegations of incompetence. The president, in this case, is facing allegations of criminality.
Yes.
I mean, I think there's a higher threshold here. And please, this is not my argument. I'm just testing it to you. There's an argument to be made that those cases are distinguishable because here the president faces a higher threshold of damage. The very fact that he's going into the witness box to answer questions of criminality and presumed lack of fitness for office is damaging in and of itself.
Yes.
That would be the argument.
Yes. We say it makes it worse for him, not better. That's exactly the point.
I see Mr. Mpofu agrees with you.
Like you, I couldn't have this.
We have what we have in common, apart from both being respondents, we both have our sons sitting next to each other in this courtroom. So he has to agree with whatever I say, because my son, his son has to agree with whatever my son's father said. Anyway, the point is this. The point is this, Justice Davis. Because it's criminality, the public deserve to know what the highest public official in this country says about those.
Well, that's another point entirely.
But it's linked. It's linked. And you've got when undermined by subjecting me to an impeachment process based on the very same report I'm challenging. Now he says, otherwise any victory I may have will ring hollow, as I would have already been subject to an impeachment process based on an invalid report. That's his case. And that's why I started with Garbus, where I said, you've got to take the pleadings. And that's his case. And if one turns, perhaps I should do that right now, turn to paragraph 1.2 of his review relief. And his review relief is immediately after the founding papers in this case. It's on page 38 of the case line bundle. The previous page he talks about setting aside the report. And he's accepted, sorry, justices, he's accepted that if he doesn't get his review, if he doesn't get his interdict, his review relief is not, that's not what he's trying to protect. He says that. I've just read it to you. So look at 1.2 on paragraph 38 with respect, my justices and my lady. He's asking for an order that any steps taken by the National Assembly pursuant to the report are equally reviewed, declared unlawful and set aside. And he tells the court that that relief will not be compromised, it seems to us, if he doesn't get his interdict. So on a pleadings perspective, he doesn't get over the hurdle of irreparable harm. Not only irreparable harm, no harm, because he'll always get that relief. He's told you. He's not complaining about the review, he's complaining about this interim period. But the interim period is protected by 1.2 in full. So the only question then becomes this dignity, reputational harm. And I've made the point, perhaps I should turn to the cases. And perhaps the best one is the Erasmus Villa de Lama JJ judgment, which is item 4, 118 to 130 of our bundle, where there are long passages dealing with the very issues that the President has raised today. And everything, well, to the extent that that's what he raises, it's fully rejected on every turn. So it starts on 118, and if one looks at paragraph 6, it tells the court what Advocate Mekubani was seeking. She says the core contention advised by Mekubani is that the entire inquiry process falls to be stayed, what we heard today, because she has launched an application for the rescission and reconsideration of a refusal, etc. And then there's the heading legislative scheme. And then there's a range of issues which I really would ask the court to consider in the fullness of the argument, but I don't have time to deal with everything. But I do want to emphasize paragraph 64 on page 123 and follow, where she says, not she, but the full court says, it is right that to succeed, the applicant must show a prima facie right that is threatened. In addition to a stay, the applicant must show prospects of success. And I'll come to prospects of success. I'm not going to dive it. There are 40 paragraphs in our answering affidavit, not in our heads of argument, which put paid to every single complaint that Mr. Trengrove made this morning about the possibility of the review, in our view. So what the court says is, if the stay is not granted, the applicant must demonstrate that she will suffer irreparable harm if the stay is not granted, that she has no alternative remedy, balance of convenience. It's paragraph 66. It is not contended by Mekubani that this process will not be followed chapter and verse. And there can't be a suggestion today that the proper course before the impeachment committee chaired by Advocate Makari's client will not be followed chapter and verse. The argument, according to our understanding, that if the now new rescission succeeds, she would then have been subject to an unlawful process. You heard that this morning. But that, of course, does not relate to the possible infringement of any current extant right which lends itself to adequate protection by way of introductory relief. I could have put that, I could have, and I think we did, put that sentence in our heads of argument. The mere fact that the law might change in the future does not grant an entitlement to approach a court in anticipation of a change in the law for interdictory relief. The argument advanced for a stay hinges solely on the prospects of success in the now pending application for rescission, etc. Now, leave out 68. I do want to read 69. Turning now to the issue of irreparable harm, which is what I'm dealing with. Again, in our view, this is not sufficiently identified by the applicant. She has availed herself to be chosen to occupy this position. Mr. Ramaphosa availed himself to be chosen to be the president. And with this high position goes the requirement to subject herself, in this case it's himself, to a lawful and constitutional process. This, in our view, cannot possibly be seen as harm, let alone irreparable harm. I understand the question in, well, it's a lawful constitutional process, but then the next sentence we would suggest is key. This notwithstanding, if the new rescission application succeeds, leave aside what's in the brackets, because I will argue that what's then included in the brackets, which is unlikely, then in that event the harm will in any event not be irreparable. It's our very case. So then it goes on. The process could then be halted if it is ongoing or be subject to reviews being completed. 1.2 of the review application. 1.2 of the review application fits into what the full court says. A full buffet of rights is then available to Mekubani, same as the president. The issue of irreparable harm is in turn connected with a link to the issue of balance of convenience. And then the issue that he says, at the bottom of the page, it also must be so that the granting of the interdict will cause irreparable harm to that doctrine of the separation of powers. It was my second foundation this morning. That if you grant the interdict, there's a suggestion that there's no harm to us. It's a few months. Us being the people of South Africa, separation of powers, that's the harm. It's rule of law harm. That if you grant the interdict, there's huge harm to separation of powers. Don't, we suggest, cross your lane, justices.
Well, we don't want to do it. And
Well,
it's not our intention to do it.
no, but you
We will
would
stay in
need-
our lane.
Well, we would suggest, my lord, if you stay in your lane, you wouldn't grant the interdict. But if you do grant the interdict, you'd be cutting into the lane of Parliament. How they've chosen to deal with this impeachment process, how they've chosen to deal with the President's request for a stay, that's their business. And I emphasize how. And there's no suggestion, there's no suggestion that the how that they employed, how they exercised their discretion to continue or not to continue was in any way misconceived, irregular, invalid, or otherwise. But that's, I've moved on from irreparable harm, I'm still on irreparable. If you're with me, that there is no irreparable harm demonstrated on the facts, which there isn't in our submission, then you won't get to the other legs of the interdict. You can't only get an interdict if you satisfy all of the legs, and if you satisfy all of the legs, then only does the court's exercise of discretion kick in. So you might have a great prima facie case, you might have great balance of convenience, but if there's no irreparable harm, you don't get there. That's our submission. So now,
You've got 2 minutes left.
well then, if I've got 2 minutes, I do want to emphasize 2 points, well 3 points if I may. The one is a point that Justice Francis picked up. And we would suggest, have a note, that as Mr. Trender I had made the point earlier and I flagged it, an incredible concession in respect of his debate with Justice Francis, and it was this. Assume that panel got the test wrong. Would that mean automatically,
Sorry, assume of that?
assume that independent panel
Yes.
got the test wrong?
Oh, the test wrong, yes.
Would that mean that the conclusion was bad? I don't know if
Yeah, yes, okay. Yeah.
And I want to offer justices a case called Hurt and Carter versus Arnson. ARNTSEN. Paragraphs 29 and 30. It's square brackets 2021. ZASCA 85, 18th of June, I think it's 2022. What happened was Lincoln Park, which is a band for people younger than myself, were playing at the DHL Stadium, and they had an activation, and the wind blew and something fell down and smashed on one of the fans, and the person died. There was an inquest. Magistrate Anson held the inquest, and she made an error of law, so it would seem. And now, Hurt and Carter, which I think is a branding agency, came to court and they said, well, she made an error, please set it aside. And what the SCA said, paragraph 29, a mistake or error of law does not per se, Justice Francis, constitute an irregularity in the proceedings or vitiates a decision of common law. Otherwise, a review in every case where there was an error on a legal issue, and then Hera versus Boyce in the old case, which dealt with a review based on an earlier provision of the Superior Courts Act. Paragraph 30. An error of law can, in appropriate circumstances, found a review in terms of the common law. This is so when the error is material and affects the outcome of the proceedings. There's no suggestion that that happened in the report. So they say prima facie, sufficiency of evidence, nitpick, nitpick, nitpick. But the nitpicking doesn't, in our view, arise to an argument and pleaded that that nitpicking affected the outcome of the proceedings. Justice Francis. So there's nowhere in the President's affidavit that the errors of law, such as they are, and I say such as they are because we're going to come to that in a second. If, for example, a statutory criterion was wrongly interpreted by a tribunal, and on application the correct approach, the facts do not support the impugned decision, a review ought to succeed. So too it can be said that the tribunal asked itself the wrong question, etc. So now I want to turn now to what Mr. Trengrove spent most of his address on. And that is, sorry, before I get there, there's a suggestion on Mr. Trengrove that the trigger is final. Every trigger is final in the sense that they always have consequences. The Speaker's decision to refer is final. So it's of no moment whether it's final. The only thing that really counts is at the end of the process. That's the real jeopardy. That's the only harm that one can cognize. Whereas the National Assembly, after this unlawful process, actually impeaches on the 247 votes they need. But up to that stage, there is no harm that is cognizable in any way, in the sense of a final harm as contemplated by that requirement of irreparable harm. So I just want to turn, lastly, and I'll ask the court to look with careful eye at pages 487 and following.
Of what? Of the bundle?
487 of the pleadings.
Of the pleadings.
So in paragraph 36, Mr. Zingula tells the court, rightly or wrongly, we say rightly, that the President's review, Part B, as he had, rests on 7 overlapping grounds. And he sets them out, and then one sees that in paragraph 36. The court see it, 36, and there's 7 subparagraphs. And what he does, in fine forensic detail, is critique every one of those 7 so-called missteps by the panel. And I'll just give the court a taste of one of them. I'm just going to choose one that's the easiest to pick up. Perhaps I should turn to, no, just taste, no more than that. Well, let me, you heard this morning this question of bad faith deliberate. Look at paragraph 50, if I may ask the court to have regard to. The panel made, well, paragraph 49, the panel went on to discuss the meaning of bad faith, with reference to the judgment of the control from paragraph 59 to 86 of the report. It is incorrect, Mr. Zingula says, to contend that the panel did not consider the defined meaning of serious misconduct. It did. 50. The panel made specific findings that the President's conduct was deliberate and therefore in bad faith. At 171.2, to contend the crime was not reported to SABC in Bella Bella, where the farm is located. As a consequence, there's no case number. Then they say there was a deliberate decision to keep the investigation secret. That's what the panel found. Now, that we would submit puts paid to that suggestion of the President's Council that the panel didn't regard the kinds of issues of mens rea, deliberation, etc. We've underlined the word deliberately conducted in the next paragraph, 50.2. In paragraph 50.3, at paragraph 263.1, the panel concluded that there was a deliberate intention not to investigate the commission of crimes at Palapala openly. So we say, as a taste, I haven't got time to go through all 7. As a taste, that demonstrates what we would call the cherry-picking, nitpicking, inappropriate manner that the President has attacked the report. There's no substance in the attack whatsoever. And we ask that the court make that finding. And we ask that the court dismiss the application. And we ask for the costs of 3 counsel where we have employed 3 counsel. There are only 2 of us here today. The third counsel who's acting and he missed his flight or whatever it was. So we will ask that the application be dismissed as a piece of the court.
Any questions? Any questions? Thank you, Mr. Advocate. We will take the lunch adjournment and we will start at 2:15 and then Mr. Mpofu will be up next. Mr. Mpofu, are you ready for us?
That he should go first.
Okay. I've got no difficulty with that. Can you just give us a second to get your heads, because we've got this. Yes, thank you. You may proceed.
My lords, my ladies, I intend to address 4 issues. The first is the question of urgency. I'll then deal with the grounds of review that have been suggested by the President. I'll then deal with the immediate res argument. I'll then conclude by making submissions in relation to the question of an interim interdict. In respect of urgency, it's now common cause that the Constitutional Court granted an order on the 8th of May 2026, which we allege is the trigger point because the course of action for the President arose on that date. We, of course, brought this application 5 weeks since that date. And what you find in the President's founding affidavit is, with respect, a scant account of why the President took so long. The substance of the President's submissions in relation to the urgency question are dealt with in the replying affidavit. And we place reliance on the decision of AXA versus Tsolo in respect of what you are permitted to do when you're pleading. You can't augment or make out a new case in a replying affidavit, which is in essence the substance, the true substance of what the President alleges to be the basis of the urgency. We then say, my lords and my ladies, when you are making analysis of the question of whether urgency has been argued and properly so by the President, you must have exclusive regard to what he says in his founding affidavit rather than what he says in reply, which is an impermissible augmentation of the submissions he initially makes in the founding affidavit. I say no more in respect of the urgency point. The bench has had an interaction with my learned colleagues in respect of what it is that the Constitutional Court found, and particularly the question of what relevance, if any, does prima facie have in contrast to sufficient evidence. And as I understand the submission on behalf of the President is that the section, or rather Rule 129G wording of the mandate of the panel does not have the qualification prima facie. That seems to be the fulcrum of the contention. But with respect, when one has regard to paragraph 139 of the Constitutional Court's order, it invokes that very wording. Because what the panel does, it bothers itself by giving interpretation of 129G, and then they rephrase, not change, rephrase what that provision provides for. And it is this provision that is being attacked by the President. And the upshot of the argument is that to the extent there's a provision of prima facie evidence and the panel misunderstands its mandate, well, let's have regard to what the Constitutional Court says. And I apologize to read to court, but for purposes of accuracy, I must do so. It says at 139, there need not be a full-blown exhaustive inquiry into every single impeachment motion that survives an initial sifting. And the crucial part is this. However, where the panel concludes that sufficient evidence exists to disclose a prima facie case, its recommendation that a Section 89 inquiry be proceeded with, and so on it goes. So the argument is this. It doesn't help, certainly on the canons of interpretation, to have a literal facial reading of the panel report. You read it within context. and we say the panel does nothing outside of what the court itself says is the correct analysis. So therefore, I submit with respect that there is no merit to the argument that the panel misunderstood its mandate to the extent it incorporates the wording prima facie. I move to the second ground of review as proffered by the President, or at least on behalf of the President. The argument there is that the panel erred in not considering bad faith as part of its analysis. What is crucial here, if I may direct the court to the panel report itself, case line 001-126.
Yes.
What you'll find in paragraph 61 is reference to Public Protector versus South African Reserve Bank, and it's footnoted at 55. And there the panel considers what bad faith means. At 71, placing reliance on that judgment, it says a proper starting point is, in my view, to remind ourselves of what the ordinary meaning of bad faith is. A dictionary meaning is intent to deceive. You then go to 72. The correct approach to determining the existence of bad faith is therefore one that recognizes bad faith exists only when the office bearer acted with a specific intent to deceive. Put differently, the panel's view on the basis of those principles say what bad faith is an intent to deceive. So to the extent you find in the report words to that effect or akin to it, then you must accept they're dealing with bad faith. What you then find in the report itself, these are the findings of the report. It says it was deliberate intention. Read bad faith. The president abused his position. Read bad faith. There was more currency in the sofa than disclosed. Read bad faith. Where you find reference to that is in the report itself, and the case line reference to these principles is in the conclusion, paragraph 80 of the report, where it deals with recommendations. So at paragraph 264, case line 001-186 is the recommendations. But where you get the wording I've just referred to is at 001-184, paragraph 263 specifically, which is a lead up to the recommendation. You'll see at 263, viewed as a whole, the information presented to the panel prima facie establishes that there was a deliberate intention not to investigate, and so on it goes. You then go to 263.4. The president abused his position as the head of state. 263.5. There was more foreign currency concealed in the sofa than the amount reflected in the acknowledgement of receipt. So with respect again, the submission that the panel did not deal with bad faith is unmerited and therefore stands to be dismissed. You then have regard to the in medias res principle that has been canvassed to a degree by fellow correspondent earlier. And I do no more than to restate the point that in the Public Protector of South Africa versus the chairperson, there is a caution directed at this court, well, amongst others obviously, that this court must have serious due regard to the separation of powers. And it is not permissible for it to grant an interim interdict in order to grant a preemptive relief. I then deal with the final aspect of my submissions, and it is this. The EFF argues that outer is of application. And it is of application because you've got the state president, who's the head of the one branch of government, trying to interdict the workings of another branch of government, which is Parliament, the highest body in that branch of government, in violation would submit of the order of the Constitutional Court, another highest body in that branch of government. That clearly invokes outer. And the President's response to that contention appears in his replying affidavit 001-6 to 8. Again, I'm afraid I'm going to have to read it to remove any doubt as to whether the President considered outer in bringing the application. The President says in paragraph 40, the EFF argues that I need to show exceptional circumstances to be entitled to the interim relief. This is based on the belief that the interim relief seeks to interdict the impeachment committee from exercising a constitutional power. Respectfully, the EFF is mistaken. So in unequivocal terms, the President says, I will not concern myself with the exercise of meeting the heightened test of outer. That's what he says in his own words. To the extent then that outer finds application and the President fails to plead the additional heightened elements of outer, then surely he can't succeed with this interim interdict prayer. And we say so because it is not an academic exercise of suggesting something that is of substance, because he has to show exceptionality as to why the interdict must be granted. And the reason it is so is because it's a separation of powers issue we're dealing with here. So it can't be a run-of-the-mill that you just interdict the workings of another branch of government without showing the exceptionality. And of course, the President does not show exceptionality, neither does he plead exceptionality. And for that reason, and that reason alone, his argument cannot stand. And the second requirement from outer is that it must be in the clearest of cases that this interdict must be granted. The President does not concern himself with satisfying the court insofar as that element is concerned. What the President seems to say is that, well, I mean, of course, it's a matter of law and it is trite that no one is to be subjected to unlawful conduct. And the report is unlawful, so the argument goes, therefore the President should not have to subject himself to the oral hearing of the Impeachment Committee. But that goes without saying. It's a principle of law. There's nothing exceptional about that. Of course, if conduct and exercise of public power is unlawful, then you've got recourse in courts, run-of-the-mill standard principles of law. There's no exceptionality about that. And of course, anyone who is unhappy about a report that finds against them would inevitably argue unlawfulness, procedural unfairness, irrationality in the ordinary course. So what is exceptional about what the President is invoking? We say nothing with respect, and again, for that reason, his remedy cannot stand. And of course, then the President says, and we submit incorrectly so, that ultimately, and reference was made to this, ultimately what he's concerned about is to protect the integrity of the review and setting aside process. Of course, then outer, we invoke to say the right to review is a right that is ordinary and is readily available, but not one that is competent for purposes of an interim interdict. And so to the extent the President invokes his right to protect the integrity of the review application, the argument stands to be dismissed in equal measure. And the President also suggests that what he's concerned about is the embarrassment and ultimately his reputation that stems or could stem, speculative, I must underscore, that could embarrass him and cause him reputational harm. Well, then if that's the case, then the President ought to have reviewed the report as and when it came out. Because conceivably, the oral evidence that will be led in the impeachment committee is that which is in the report. And the report has been in the public domain for at least 4 years now. So it's not so much the President is concerned about, it's not so much the reputational harm evidently that he's concerned about. He's concerned about the consequence of the report, which is possible impeachment, hence we are here. There is no magic in oral evidence restating that which is written on paper in a report that he has never challenged up until this point, when the consequence of that report is potential impeachment. That's the President's genuine concern. And we know that the President was not concerned about the contents of the report, which is in the public domain, because, again, as he would have started with a constitutional court application, it was when the consequence of the report, i.e. his possible impeachment, was of concern. He goes to the Constitutional Court to have the report set aside. The question becomes moot because the National Assembly votes in his favor. He does nothing. He tells us he does nothing because the report is of no moment, damaging to his reputation as it is. He then, when again the question of the report and its consequence comes to the fore, the President yet again wants to review and set aside the report. So in earnest, what he's concerned about is what the consequence might be rather than reputational integrity. I want to then deal with the question of what the Constitutional Court found in respect of whether the interdict would amount to halting or frustrating the order of the Constitutional Court. Our submission in that respect is this. The court bothers itself by giving an analysis of what 129G means and what the mandate of the panel is. It appreciates that it is only to the extent that there is sufficient evidence to show that there is a prima facie case that will be considered by the impeachment committee. It then concludes by saying it must go to the impeachment committee. What must you draw from that? It would have considered the question, because of course the Constitutional Court cannot suggest, in the face of concerns about the lawfulness of the report, direct that it be heard by the impeachment committee. What we submit, the words subject to the review add no value to the principal point, because of course the President remains with the power and ability to so review if he so wishes, because the Court can't foreclose that door. But the submission is that they would have considered this report, and most of the people here were there in the Court, and we make the point in our papers that at the very least 80% of the engagements was on the question of the report and its lawfulness. Something must be read into that we submit. But of course then the Court can't simply say...
That is not for us now.
Well, I thought I would take the chance. And the point is this. Ultimately, there's a myriad of grounds that the President can rely on, because have regard to the fact that the Rule 53 record was not provided to the President at the time. It could well be, having considered the Rule 53 record, there is potential another ground of review. It could well be that they foresaw that, hence the qualifier. But it still does not take away from the fact that the Court bothered itself by giving the appropriate test when a report is fit to be considered by the impeachment committee and directed that it be considered by the impeachment committee. Penultimately, On the balance of convenience analysis, Alter says the separation of powers harm is harm in itself. So in other words, the very idea that this court is being asked to intervene in the operations of Parliament, that in itself is harm. You must show exceptional instances why they should deviate, notwithstanding that patent harm. And again, to restate the point, the President did not concern himself with that exercise, and it was not shown that it is in the clearest of circumstances that the interdict must be granted. We then say finally, of course the President has got an alternative remedy, and it is this. And it was suggested earlier on that you could go to the Impeachment Committee. And in understanding truthfully what it is that the President seeks to do, you must have regard to what he says is his concern and how he wants to remedy the concern. And at the height of his concern is reputational damage on the basis of what appears in the report and what could potentially come out of oral evidence in the impeachment processes. That's very important to bear in mind when you consider the question of an alternative remedy. What the President purports to be his refuge to safeguard against that is to, on technical points, have the report set aside rather than answer the question of the veracity of the claims. The veracity of the claims can only and only be dealt with at the Impeachment Committee, where it's got an opportunity to put forward evidence that disturbs the conclusions that were found or made by the panel itself. And that would truly remedy his concern, which is of reputational harm. It is him showing his innocence of the charges that will truly exonerate him. It is not a technical
But
argument.
doesn't that put an onus onto the President, that he must prove his innocence?
Well, perhaps it is even unfair to suggest he must prove his innocence, because all he is a witness before the Impeachment Committee. But the point is, if ultimately he wants to disturb the findings that there is prima facie evidence, sufficient evidence rather, that shows prima facie case, if he wants to disturb that finding, he must provide the evidence. And to the extent he can provide such evidence that disturbs those factual claims, then true exoneration, as we understand it from the President's perspective, would come about, rather
But
than.
the President says he's already given a version of events, and that's it.
Well, he hasn't been examined on it. The veracity goes slightly. There's a process that is far beyond what the panel had done, and of course know the limitations the panel has. But I think more importantly, as with every matter of evidence, for it to be truly tested, it must be tested on examination, and contravening and countervailing, or rather contravening evidence may be led. It is only then you can get to a conclusion as to whether there is merit to the President's defense. After all, it is at the Impeachment Committee that the veracity needs to be made, and that is after examination, and that cannot happen except for
But
the
will that
Impeachment
not raise
Committee.
harm towards the President if, for instance, they use a report which ultimately going to be found whether unlawful or not? Now the Impeachment Committee gets their teeth into the President and put him on the spot
Well, I mean,
by being cross-examined on something that, if it was not there, they couldn't have done the cross-examination on.
no, absolutely, my Lord. But
Is there not a harm in there?
I accept there is. But what I'm saying is what's exceptional about that. It's in the ordinary course where people are subjected to reports that are against them, then they are tested, and if they come right, they're exonerated. I mean, not to stretch the argument, it's common in criminal matters where you're accused of conduct. You put your version and you're exonerated in due course. There's nothing exceptional with the President, with due respect. There is nothing that's being asked of the President that is not asked of anyone else who's a member of society. So there's absolutely nothing exceptional neither has there been suggestion that there's something exceptional. That is, the state president is of no moment for purposes of the legal argument I make. If I may then, Your Lordships, just turn my back to see if I've covered.
Yes, you may. I see Mr. Mpofu is licking his lips here. He's ready to go.
I'm being asked to deal with the question of the indeterminate nature of the stay of the impeachment process. And of course, we know that the President has said he only seeks an interdict insofar as the review is concerned, and once the judgment comes, the interdict ceases to exist. But of course, he qualifies. He then says we'll take a point or take the position and reconsider at that point. So it's an indeterminate nature of the interdict that we're dealing with here. And he does say, well, we'll have regard to the Superior Courts Act and we know what the implication there is. So it is not as a humble a request with respect has been suggested. And unless, of course, there are questions from the bench, those are the total submissions.
Let me just find out from my colleagues. I don't know. Do you have a question? Thank you.
Let's go please.
Mr. Mpofu, ready?
Thank you. Lady, my lords, what Mr. Kasbote did not say was that there's a bargain, but him donating some of his time. But he stuck to his end of the bargain, so I'll also try.
But just remember the old age saying, brevity is the hallmark of a good lawyer.
Absolutely, absolutely. And he has just displayed that. So I pay tribute to him. I'm afraid this case has just been approached from a quite an awkward position by the President's papers and the presentation this morning. And one of the curious features is that Mr. Tengov, with the greatest respect to him, so this is a non-scientific estimate, spent maybe 60-70% of his time on the review, on the issues to do with the review. Prima facie case, all those things, and I'll come to that. But this is not the review. This is part A. The only allowable way in which we look, to use the EFF versus Godin, we peek into the review grounds, is for one sole reason: to determine whether the criteria in outer have been met. One, is this the so-called clearest of cases? You can't do that without peeking into the review grounds. Two, are there exceptional circumstances in this matter? Again, you have to peek into the review grounds. And you then, once you've determined those criteria, the other important reason is this issue of outer, paragraph 50 of outer, 49 and 50, where it says that you are not allowed, in establishing your prima facie right, to, as it were, pull yourself by your own bootstraps and rely on the fact that you have a review. It's not allowed. Musanega DCJ made it very clear that is not allowed. So those are the only reasons for picking into those Part B. But we must leave the issues of Part B to the Part B case. And I will show this court, with the greatest respect, that the Part B case is in any event a hopeless case, which is unlikely to succeed, to use the phrase used in EFF versus Godin. And if we are right that that case is unlikely to succeed, then for that reason alone, this court may not grant the interim relief. So let's park that. The other deficiency in this approach is that in the case of Gool, Gool, which is one of the cases that gave us, the pre-constitutional cases that gave us the outer test, it was said that one of the reasons for which can justify the court interdicting the exercise of statutory power or constitutional power in this case is if the applicant alleges mala fides. In this case, there is not even a whiff of suggestions of mala fides on the part of the panel, on the part of the committee, or the speaker for that matter. So on what basis can this court intrude into the exclusive terrain of the legislature, and I will show now, even intrude into the exclusive terrain of the judiciary for that matter, in a case? Because this case, in terms of the so-called separation of powers harm, is actually very, it's a heightened one, because not only does it want to interfere with the judgment of the Constitutional Court, it also wants to interfere with the functioning of the legislature. So there is simply no basis. Mr. Katz is 100% right. There is no basis upon which this court can cross what is said, the court must stay in its lane, as he put it. There's no way that the court can cross into the other lane. None of the usual justifications which are set out in outer and cases like that apply here. The court, with the greatest respect, it doesn't matter what the court might think about the rules, about the period that it's going to take and what have you. That has got absolutely, to put it crudely, nothing to do with this honorable court. It is a matter that is within the exclusive terrain of the judiciary. The only exception to that rule, and that's why Mr. Katz's quotation in EFF 1, what you must emphasize there, he emphasized the word how, but in that sentence, he de-emphasized the word whether. That's where the crux of that quotation is. The court, it says there, is allowed to look into how. In other words, if or rather, is not allowed to look into how the methodologies of the legislature and so on, but it can look into whether those are lawful or not. That one, the court is not even asking for anybody's permission. That's the function of the courts. Once I come and I say, they did this, it was 3 days, 4 days, the court says, well, there's no, tough luck. But if I show you that which they did is unlawful or irrational, then no one else can deal with that except the courts. That's the separation of powers. That separation of powers was set, it comes from the Grootboom case, the TAC case, all the cases the court is familiar with. That is why you'll remember there was a, shall we call it a skirmish in the EFF 2 case, which we did between Justice Mogoeng and the majority, and even Justice Froneman. Because Justice Mogoeng was saying, the Chief Justice, he said, this is the classical case of judicial overreach. And rightly so, the other judges rebuked that statement. And they said, Justice Froneman, actually, his dissenting judgment was just on that point. Because he said, no. It's the function of the courts to determine whether there is illegality or not. As to how and all that, then that would be interference. And Justice Chafter said courts do that every day, which is true. Okay, let's put that. I will come back to that as well. Let me just, I just wanted to get those broad submissions.
No, don't come back to it. Finish it off.
Well,
I don't want you to come back to it.
So let me just give you the
Okay, yes.
layout. I'll explain why. Anyway, let me rather accept the invitation.
Yes.
Now, this, because it deals with the layout which I was going to do. My lord and my lady, there are 3 legs to this case. The one leg is the preliminary points, which I'll deal with very briefly. The second leg is the review grounds. I told this court how important or unimportant they are in this case. And then the real merits of this case is the requirements for an interdict. Those are the 3 legs. Now, to come then to maybe just to respond to Justice Lefrance's invitation, I will still come back to it, but let me finish this thought. That I'm going to impress on this court with the greatest respect that the case presented before you does not even meet the Sitlogelo test, let alone outer. Let alone outer. It does not even meet the most basic requirements of the old Sitlogelo test. I've already explained why a prima facie case has not been made. You can't make a prima facie case by saying, I have a right to review. That's out. Second requirement of Sitlogelo, irreparable harm. Where is the harm? The only harm you can talk about with the greatest respect is the harm that has been pleaded. What does the president say? He comes here and he says, well, I cannot be put through the humiliation of accountability. What? What happened to the people of South Africa? We're all worried about the humiliation and all these things about the president. What happened to the people of South Africa? The people of South Africa can only hold the president accountable through their elected representatives, which is parliament. That's the only tool in the hands of the people of this country to get the answers of what happened in Palapal. It's the only tool. Who's going to talk about the damage to them?
But what damage can there be to the public in general speaking if money gets missing, your own money gets missing, gets stolen? What damage is it to the general public?
Yes, no, thank you, Justice Lekhat.
I mean, that's not for us to decide now, but I'm just throwing it out there for you.
You've asked the question, so the answer is going to come.
I mean, the people steal his own money. I mean, so what? What's the damage to the rest of South Africa about that?
No. Let me just answer that very briefly. And I'll answer it by referring to something that Justice Davis raised with my learned friend, Mr. Katz, about the public protector cases. I'll answer it with a rhetorical question first. Is it more pressing for the people of South Africa, as this court held in 2 cases, to know whether their public protector is incompetent than to know whether their president is involved in criminality? Is the kind of disdain we have for the people of this country that we say they do not deserve to have answers, yes or no? Because the answer we don't know, it might be yes or no. But they don't deserve an answer, yes or no, whether their president is involved in criminality, whether he's involved in the torture of domestic workers or the hounding of people in Namibia because they've left with his dollars. Or what happened to General Mfazi, who was murdered around this whole thing, and who's mentioned in the report as the most senior policeman who received this information. Can we really say that? Or, put it differently, is it more important for, I'm talking about other impeachments now, the impeachment of judges? There's a judge who was a board member or something like that, who was impeached. So is it more important for the country to know whether the judge is a board member and so on, than whether the highest citizen, the number one, the epitome of the Constitution, the constitutional being, may or may not be deserving to be wearing orange overalls? Is that what we're saying to the people of this country?
But in order for that to continue and to be interrogated and to get to the veracity,
Yes.
the impeachment committee must rely then on the report.
Yes. 100%.
Now, but absent the report, then on what are they going to rely upon?
No, I understand the question, Justice Lukhanz. But the question doesn't go like that. I'm afraid. Yeah.
So, how must I phrase my question to you then?
This is how it should be phrased, Justice. Assuming, and I'll explain why I'm saying that. Assuming for a minute that the report is valid.
Well, it's currently valid as it stands.
Well, I'm coming to that here. And because the other notion that in all of what Mr. Trenkov is saying, he's basing it on the assumption that it's invalid. And I'll show that that's wrong, that cannot stand at all.
It's valid until set aside.
Absolutely. Until, assuming therefore that it is valid, in other words, let's put it at its lowest, that the president has a case to answer on these things. Let's just assume that. Then the question becomes, can this court then stop in its tracks the process to exactly find that out? And put aside questions of separation of powers for now, but just purely at that level. In other words, and one of, I think it was Mr. Kasibot who makes this example of a criminal case. We all owe the duty for criminal accountability. So if somebody says, I stole my learned friend's pen here, and he goes to the police and he says, I stole his pen, and then I'm charged with theft, my duty is to go and exonerate myself. I can't say...
No. That's not the way it works. The state must
Yes, I'm coming to that.
call witnesses to prove beyond a reasonable doubt that you in fact did steal the pen.
No. Let me
Is that not in criminal cases?
No.
Okay.
Let me explain the process.
Okay, you
This
do
is
the
what
go
happens, Justice Lukhanz, in reality.
Oh.
The police, he's going to go to the police, right? The police will make an assessment. They say, this guy is just, you can see, he can't even, and then they'll say, okay, fine, and drive him home if he's not okay. But if they think that, if he says, look, I had this pen, it's my most precious pen, and Pofu took it, then the police say, it looks like there's something in this, and they take one step. Then they take it to the NPA. The NPA does a different assessment. It does what the speaker is supposed to do. Looks into the mechanics, that it can't verify whether there's admissible evidence and so on, and it says, okay, there's a case to go to court. And then it goes to court. Then it goes to court. Then the court, trained in that craft, makes at the stage of Section 174 whether there's a prima facie case at that point. That's why they make that example
Yes, but no, the point I wanted to make, Mr. Mpofu, I hear what you're saying, is that the state doesn't call the accused first and say, come, you must now explain to us the affidavits that's been filed by the witnesses. And then you cross-examine the accused first. Doesn't happen in criminal matters that way.
Fair enough. That I accept. But that's not the point. The point I'm making is that the police in their investigation will come to me and say,
yes, of course.
Yeah. So I'll give my version. even the NPA, by the way, will also look into my statement before they make their
Yes.
decision. But I'm making a different point, Justice Leclerc,
Okay.
which is this, that Mr. Tengov is completely mistaken in conflating the prima facie assessment that is done by the Speaker, which is a mechanical exercise, that's the NPA example, to the one that is done by Chief Justice and a judge and a senior counsel, which is a completely different exercise. The fact that semantically you use the word prima facie, even for the NPA, doesn't mean it's doing the same job as the court. That's really the point I'm making. In other words, because the argument is supposed to be a rhetorical question. Well, if they are doing prima facie, then the Speaker is also doing prima facie, then what's the point? But these are two or three different stages. And the proof of that is here. Mr. Tengov's argument actually turns against himself, because he says, rightly, in the rules to do with the public protector, there it says plainly the panel must do a prima facie assessment. But in those rules, it also says that the Speaker must do the prima facie assessment. So that's a non-argument. It turns against him because it shows exactly the point I'm making, that those are different standards that are being applied. So okay, let's move that point.
No, before you move that point.
Sorry.
So, do I understand you correctly that the panel must establish what on whether sufficient or prima facie evidence if there's a case for the President to answer?
Okay. That's all. Okay. With the greatest respect, this distinction between sufficient evidence and prima facie evidence is absolutely manufactured. The Constitutional Court made it clear that those two things are synonymous.
But you must agree the way the Speaker looks at it must be different from the way the panel must evaluate it.
No, absolutely. Okay. No, yes, Justice Lockhart, let me be very clear. There are two distinctions that we are making. The one that we are making now, which is the two prima facies of the Speaker but now I was addressing the other distinction between sufficient
yes, I know.
And that's the one that I'm saying is artificial. And the reason why it's artificial is that in the famous paragraph 139, you see that the Constitutional Court uses these terms interchangeably, or in the same breath, so to speak. It says, however, where the panel concludes that sufficient evidence exists to disclose a prima facie case. And that's the exact question that the very first question Justice Leclerc put this morning was about this, and it was not answered with respect. Whether isn't really this thing much ado about nothing. All they are saying is sufficient evidence to disclose a prima facie case. If the Constitutional Court, no lower than the Constitutional Court, uses this in the same breath, who are we to say, no, this one is in the West, this one is in the East? It's not. And to cut through all those semantic debates, we come back to what we are saying, Justice Leclerc, which is all, and this court, both in EFF2 and in this case, they've said that all that really is needed is there a case to answer. So let's not bother with these niceties. Is there a case to answer on the pala issues, yes or no? If there is, go to the committee. If there isn't, go home. It's as simple as all that. And Mr. Trengo says that paragraph 76 of the report, he praises it of eloquence. And you'll find that at (001-131).
Paragraph page 76
of the report.
Of the report.
Sorry,
yeah?
of the ICE report. It's at page 131. Now, you'll see that paragraph, which Mr. Trenkov says is so eloquent, puts the standard of a case to answer 3 times. It says, we think that
No,
the purpose...
give me a second to
I'm
get
sorry,
there.
sorry,
Give me a
Justice.
second. Yes.
This is what the panel says, chaired by none other than Justice Ngobo. Anyone who knows about Justice Ngobo's writings will know that he certainly considered this very carefully. He says, we think that the purpose of interposing the panel in the scheme of the impeachment process and entrusting it with the power to conduct preliminary inquiry, underlined preliminary, into the motion was intended to ensure that the President is not required to undergo a full-scale Section 89 impeachment in circumstances where the President has no case to answer. That's the first. Then they say that step must never be taken lightly. It is a momentous act, as Mr. Chenkov's favorite quote, justified only when sufficient evidence exists to show that the President has a case to answer for his conduct. 2. And then it says the panel, therefore, functions as a filter to ensure that only a motion which establishes prima facie that the President has a case to answer is considered by the impeachment committee. I agree with Mr. Trenkov, it's very eloquently put, but it couldn't be clearer than the fact that the standard is a case to answer. Then, let me go to this very quickly, because Mr. Trenkov didn't address it, but maybe he'll address it in reply. The other artificial distinction that they make in the grounds of review is a distinction between what they call evidence and information. The court will remember that. Mm-hmm. That is another red herring. It's obfuscation and trying to pull the wool over everybody's eyes. If you go to Rule 129(1)B, 129 big A 1B, it says that what must be given to the Speaker is all information, all pieces of whatever, and at 1B it says evidence. Okay. In other words, Mr. Zungula's motion it could contain newspaper cuttings or whatever, but also include the evidence that he has. So when that package, let's call it, is then given to the panel, it already contains the evidence. That's why there were sworn statements from General Rode, I think the sworn statement from the President himself, and so on and so on. What the panel may not do is then to say, oh no, this one passes the hearsay rule and all that. That's the job of the committee. So all the panel needs to do is to say, on this information, which includes evidence, is there sufficient evidence to establish a prima facie case, yes or no? And if it passes that threshold...
Isn't the function also of the panel to because the first package carries all information.
Yes.
That's information,
good and bad.
But isn't the function of the panel also then to inquire whether that information have probative value?
No.
No? Okay.
Because
if it's just a gossip story, then why must that be part of the panel's
fair enough. I now understand
consideration?
Yes, absolutely. I'm sorry. Your logic is quite correct. That, by the way, is the reason why I made that earlier distinction. That is why this time, and the presiding judge is quite correct. This time, you're not just looking whether they dotted the I's and so on. You must have 3 trained lawyers who will do the exercise and look at that. And to be fair, in this report, that's exactly what the Chief Justice and these 2 panelists say. They say, we've looked at this. Remember, in paragraph 50, and that comes, I think it was a question raised by Justice Davis as well, or Justice Lefranc, about whether to Mr. Tengov, did they not consider the president's version? They go out of their way to say, even on the president's own version, forget everything else, forget Mr. Zungula and what have you. On the president's own version,
There are gaps.
There's a case to answer. And at paragraph 50, they answer the question one of the judges put, I can't remember which one, about to the extent to which that version is. They say that even though the rules do not say we must consider the president's version, obviously, by the mere fact that the rule says we must get his statement, it means we must look at his version. You'll find that in paragraph 50 of the report 001-123.
It's paragraph 50, yes.
50, yes, my lord.
Yes, the rules do not say so, but it seems
Yes,
obvious.
yes, absolutely. The rules do not say so, but it seems to us obvious that the panel is bound to also consider the information placed before it by the president. Otherwise, there would be no point providing the president with copies of the information that was made available to the panel and providing the president, quote, with a reasonable opportunity to respond to allegations against him. This is completely sensible, because what they are saying is that we're not doing that other tick boxing exercise. We are, or box ticking, I think is the right word. We are here now weighing what Mr. Tengov said they didn't do. We now have to weigh these things. And the presiding judge is quite correct. Because the reason why this needs lawyers is because they can say, I mean, if this thing comes from some back of a cigarette box, and then they'll say, okay. They even go as to say, to criticize Mr. Fraser's evidence. They say Mr. Fraser's evidence doesn't have corroboration in one sense, and therefore, to that extent, I think they were discussing a particular thing. To that extent, it's hearsay. But in the next paragraph, but they say even the president's version is also hearsay, because he doesn't put the statements of Mr. Ndlovu and Mr. von Weiler, who was supposed to have received the dollars. But all those nice things will be resolved in the committee, because the committee will be able to subpoena Mr. Ndlovu and this one and that one and so on. The panel doesn't have the power to do that. Now, so what we then have is that all the pleaded harm, whether it's in the form of potential defamation, whatever that means, or the ignominy of being placed to account. I mean, if it's ignominious to be placed to account, then what is the president doing in parliament all the time, answering questions, some of them frivolous and politically charged and so on? It's because he has a duty to account. Nobody forced him to be the president. Once you assume that office, and this is what this court said, by the way, in one of the public protector cases that Mr. Katz kindly dealt with and relieved me of that duty. As the court would know, I was in both of those cases. This court, 3 judges, twice, said to us, we came here the first time, we said, judges, there is a big prejudice and irreparable harm because the rules themselves are unconstitutional and so on and so on. The judges said, no. The duty to account is higher than whatever you perceive. The impeachment committee must go on, and it did. We even went up to the Constitutional Court. What is worse is that the Constitutional Court agreed with us. It said this court was wrong on the question of whether we're allowed for legal representation or not. But it was too late. We couldn't come back now to Justice Saldanha and say, yeah, you see, we were right. It didn't matter. It said even though we were proven to be correct on at least on 1 or 2 of the grounds of illegality later, but it said in the meantime the process must continue. Then we went. Then somewhere in the middle of the process, there was a question about the bias of the chair and a person who came from the DA whose wife was the complainant or whatever, and we raised the recusal application. And so we came here again. We said now we are in a better position. It's very clear that there's conflict. this person is married to this one and and all those things. The court said, thank you very much, we hear all that, but you cannot interdict a process of accountability. Go and fight your part B about all these good things about recusal and so on. Justice Erasmus, Vele and Dolamo, sitting in this court, actually I think this very room, said to us, no, and I'm not going to go through those passages, but please, I implore this court to look into both the judgment of Justice Saldana and Justice Erasmus. And it's 100% correct, unless this court, for some reason, finds that those judgments on the question of accountability and how crucial it is were wrong, clearly wrong, then this court is bound by its own decision, let alone what I'm going to show you now, that you are also bound by the Constitutional Court. But you just, for starters, bound by your own decision.
What do you make of the argument that was raised?
Sorry, Justice.
That's saying that those matters can be differentiated from this one.
Yeah. Well, I've already answered that question by that rhetorical question. How could it be that a public protector, the accountability of a public protector is more egregious than this case? It can be on anybody. You can go to the taxi rank and ask anyone, would you rather know whether your public protector is incompetent or whether the president had stashes of money and all the things that I've said? The answer will be the same. Now, this is what it said. This is another case that I did against my learned friend, Mr. Trengove, where he successfully argued the following. It was a case of Moyane versus Ramaphosa and others. You'll find that at 013, I can't read this, 239, it starts there. But the passage I want to read is paragraph 38. I had argued all these things that Mr. Trengove is raising here. Irreparable harm, my client is going to be put into the ignominy and so on, and he had to go to the Nugent Commission and what have you, and the whole world will be watching and so on. And this is what the court said at paragraph 38. I've already dealt with most of the considerations in the context of weighing up the balance of convenience. Selfish personal interest cannot be weighed up against the national interest and the stability of the revenue services in the context of the South African economy as a whole, and so on. That's the sting. The sting was that, selfish or otherwise, the personal interest of the individual weighed against the national interest of accountability is a no contest, to put it mildly. And therefore, and we failed. The court did not grant us that interdict for that reason. It said you might be right. It might be very embarrassing to go to the Nugent Commission and all these things. Your client might be completely innocent, but we cannot interdict that process because, firstly, it would be an intrusion into another domain, which is the separation of powers harm. But secondly, whatever harm pales into insignificance compared to the national harm of even the remotest possibility that your president is a criminal. The remotest deserves to be aired. It might be that, and I think Justice Francis made it clear in the morning, that here you even have a better chance because you have a chance at exoneration. That's so the only way in which the president can be harmed in this situation is if he's not telling the truth. Because if he's telling the truth and he is innocent of all these things, it's all a big misunderstanding, then he will go down as the Mahatma Gandhi of South Africa. Because
Yeah, but the point the president wants to make, I think, is this, that his political adversaries wants to nail him in that committee.
Well,
although the chairperson of the committee indicated that he will protect the committee.
Fair enough.
But he can't protect him against the report, you see.
Yes. No, thank you, Justice Grant. I think that actually is the question you put to Mr. Katz is a very serious matter. The president, it does not lie in the president's mouth to say, I'm afraid of accounting because my political adversaries are going to take advantage. That's what he does every day. When he gives SONA, he gives SONA for an hour and a half. And then for 2 days, his political adversaries are on his case. Why? Because he has to account to the nation. So and Justice Legrand, which is more important, the process of impeachment is by definition political. Okay? It's not a court where you could go and coast and say the best evidence in that committee and cross-examine all the witnesses to death. I speak from personal experience.
Oh, yes, experience.
Yes. And then the report is taken to Parliament. Yes, they vote like that. Then another, no, yes. And that's it. 1, 2, 3, 4, 5, boom, you are impeached or not impeached. It's a political process, deliberately. The Constitution deliberately made it a political process because it would have said it must be a vote of the judiciary. No, it said it must be a vote of the legislature. Those people, all 400 of them are politicians.
But on that point, because it's political in that nature, shouldn't there be a buffer, as pointed out by Mr. Trenker, because that no silly motion can just come past here for the president to be impeached?
Absolutely.
And therefore the report is so vital in that regard.
That I agree with Justice Legrand with respect. Because remember, even the speaker, let's get an example. There might be a speaker, let's say from a different party or whatever. Even the speaker might say, oh, well, I'll overlook these defects because I don't like this particular president. It's all political. The constitutional drafters knew that. And that's why they introduced this sifting mechanism, which is independent. So that in the whole process, which is political from beginning to end, there must be a buffer which checks from an objective point of view, is there a case to answer before we can go to all these things. If there isn't, you stop there. It's the same process as the Judicial Conduct Committee in the JSC, where I used to sit. In the JSC, this is how it works. The JCC, a complaint comes, this judge did this and another, and then the complaint comes to the JCC. The JCC then does the first sifting mechanism, or rather, actually the Chief Justice does the first one, and then the JCC does the second one. Once Section 16.4 of the Judicial Services Act says, once the JCC is satisfied that there's a prima facie case, then one of the things it does is to refer it to the JCT, which is the Judicial Conduct Tribunal. That's our impeachment committee equivalent. And so there's nothing magical about this. All people who are impeachable in this country, heads of Chapter 9 institutions, judges, and the president go through the same point. Sifting mechanism, there must be an independent determination before you are put into the so-called ignominy of the actual trial or inquiry. Now, all of this, by the way, and this is where I should have started, because interesting as everything I've just said, it might come to nothing because the court has no jurisdiction, this court.
You've been speaking now for almost 45 minutes and tell us now that we don't have jurisdiction in this matter.
I thought, Justice Francis, since we're here, let's just show how hopeless the case is. Now, let me, on a serious note, Justice Francis, this court, with the greatest respect to this court, cannot second guess, undermine, vary, amend, alter, whatever word you want to use, a judgment of the apex court. That I'm sure we agreed on, all of us. So that begs the following question. is the order that is sought here consistent with the order of the Constitutional Court? If it is, then I'm wrong. But if the order that is sought here seeks in any way, small, tiny, minute, to alter what the Constitutional Court has said, then this court cannot do that. Now let's go to paragraph 139, the famous paragraph 139. I will show this court that I enjoyed the debate between the presiding judge and Mr. Mkari about whether, because I was also toying with this thing for so long, whether at particular points is the court talking about this report or talking about reports in general. It's a very interesting debate. And one of the shortcuts to it is if you go to the court order, you'll see in the court order where they used small letter P for panel.
Just hold on.
Again, not scientific, but if you go to the court order, the one which has the scratchings, Justice Lufans, you'll find that at paragraph 7.
Yes.
So you'll see that they say, let's take paragraph 4, for example. It says, in the event that the panel concludes sufficient evidence does not exist, and so on, and then that's why they say they use the small letter P. But in paragraph 139, you see that they talk about the impeachment committee with capitals. That's just my shorthand. As I say, I'm not going to go to war over that. The point I want to make is at 139, which is the following. And thank God I won't go through the debate that the presiding judge had with Mr. Mkari. I'll use both, I'll assume both. Let's assume for a minute they are talking about this panel. And then also assume they're talking about any old panel. You'll see that what I'm going to say fits both. So this is what they say at 139. Where the panel concludes that sufficient evidence exists to disclose a prima facie case, its recommendation, underline this, that a Section 89 inquiry be proceeded with, must be implemented through a referral to an impeachment committee. Here are the big magic words. Unless and until the report is set aside on review. That's the end of this case. So what the Constitutional Court was doing here was to design, and I'm using shorthand because the judges will understand quicker. They were designing an eau de Graal rule, if you like, for these kinds of things. So they're saying, if the panel finds that there's sufficient evidence, then that report, as you said earlier, must be presumed to be valid unless and until it is set aside when? In the future somewhere. So what does that mean? It means the words until and unless, and I've never looked at words like that for such a long time. Yeah. Until, according to the Oxford Dictionary, means except, unless means except if, and until is about time. So until means, if this court says, I'm postponing this case, Mr. Mpofu, until the 1st of January 2027, I can't then come back and say I want it to be heard in November without altering that order. So if I want to vary the order, if I say I'm going to have anonymity and irreparable harm and what have you, I come back to the court and I say, court, I know you said we'll come back on the 1st of January 2027, but because for these reasons, can we do it earlier? Until that event happens, I am forced by reasons of section 165(5) of the Constitution to comply with the order. Or I can rescind it, or I can appeal it, or I can do whatever I want. Yeah.
But now I do want to review.
Yes.
Say, for instance, the person says, look, I want to review it. But I've got now my review application
Yes.
that has been filed. But my review application is split into two, a
Yes.
part A and a part B. What's wrong with that?
A lot.
Oh,
A lot is wrong with that. Let me explain. I'm so happy about that question, because that's why I part ways with Mr. Mkari on this issue of, and there was a debate between you and him about whether that clause also prohibits the review. We don't argue that, at least not for now. I think it's quite tempting when I read Mr. Mkari's heads, yeah. But we don't argue that. So we depart from the point of view that the president is entitled to review the report. Even now, I, as I say, on a serious note, I agree with Mr. Mkari's analysis about and so on. But before this court, we don't argue that. All we're saying that this court has no jurisdiction to do is to give interim relief pending that. Now, let me explain, Justice Ilkhanzi, because this is the most important. This might well be the most important part of this case. If the order that you are asked to grant now is going to disturb this pronouncement that this thing is valid until it's set aside, not until you lodge an application for a review, not until you put a Part A application, not even until you get a judgment in the Part A application, no. Until it is set aside, in other words, until the outcome of Part B. And I have found overnight, and if I can just apologize to the court, I will only, my attorneys only made 3 copies, so I want to use, I'll hand it up after I've quoted it. There's a case of Tubular Holdings, LTD versus DBT, 2014 bracket 1 SA.
sorry, 20?
2014, my lord. Bracket 1 SA 244 GSJ.
GSA.
GSJ, Gauteng, yes. And then the other one is Freeman NO. I will hand them up. And another versus Eskom Holdings Ltd 2010 ZAGP JHC 137. These cases, because I kept on saying to my learned juniors, there must be something about, because why am I so fascinated about this expression unless and then until? And they kept on saying they can't find anything until they found these cases. This case, the Tubular Holdings one, my lord, says this is a judgment of the Gauteng court. And I'll just quickly go through paragraph 5. It says the essence of this dispute, it was a contractual dispute, of clause 20.4, I think of the arbitration clause or whatever. The applicant submits that the parties are required to give prompt effect to the decision of the DAB, which is binding unless and until it is set aside by agreement or arbitration following a notice of dissatisfaction. Whereas the respondent says that the mere giving of a notice of dissatisfaction undoes the effect of the decision. Exactly what is happening here. So there was a clause that says unless and until the arbitration process sets aside whatever it sets aside, the process must continue. And then I'll refer the judges, particularly paragraph 24. But the 24 is other cases. They give other cases, including English cases that deal with the same process. If the court can just bear with me 1 second. I just want to find my reference. Sorry.
I don't want to disturb your research there, Mr. Mpofu, but is the short point you want to make is this. If one have regard to what the Constitutional Court has said here, is that unless and until set aside, this court cannot interfere with
Yes.
that order.
I'm sorry, my lord.
This court cannot interfere with that order. And therefore, according to you, we lack jurisdiction to grant interim relief.
Yes. I'm saying, yes, my lord. I'm saying two things. I'm saying, firstly, the effect of this pronouncement by the Constitutional Court, which is binding upon you, is that's why I call it a mini eau de cral. It says, unless and until that happens, we know in eau de cral. Eau de cral works like this. I can go to court and say, this tender was given to Mr. Tengo, which should have been given to me. It was a complete miscarriage of justice. But eau de cral says, until it is set aside by a court of law, it is valid. And that's really all that the Constitutional Court was saying. It was saying, because of all the importance, all the things that we know, this is important, accountability and so on and so on. The magnanimity, not magnanimity, what is it? The ignominy of being placed into a process which might later be reversed counts for nothing. Just as the ignominy of me carrying out a tender that we'll know later it might be reversed is. So what the Constitutional Court was making was putting a rule of law. Rule of law says in impeachment proceedings, when once the independent committee says there's sufficient evidence for a prima facie case, then the process must continue unless it is set aside. In other words, and this is what was said in this case here. It says, I therefore find, I'm reading from paragraph 25 now, I therefore find that the terms of the relevant contractual provisions are pretty clear. The parties are obliged to promptly give effect to a decision of the DAB. The issue of a notice of dissatisfaction does not in any way detract from this obligation, or part A, or an interdict, or whatever. While such a notice is necessary where the dissatisfied party wishes to have a decision revised, it does not affect that decision. It simply sets in motion the procedure by which the decision may be reversed. But until revised, the decision binds the parties and they must give prompt effect to it. That's the principle that is found in 139. In other words, in that case, it was saying the notice of dissatisfaction, let's call it notice of motion, of part B, doesn't even help you. You must comply with the process until the judgment. Now, this court, with the greatest respect, cannot say, no. We hear what the Constitutional Court is saying, but we, in the Cape High Court, find that you actually, the inquiry may not proceed unless and until the report is set aside. It must be stopped now. It's not possible.
No, sorry,
Justice Francis.
The Constitutional Court has contemplated a review
Yes.
of a panel report.
Fair enough.
Now, what is the purpose of having a review that cannot be exercised until the whole procedure has been
Yes.
sorted out?
Yes. Thank you, Justice Francis. No. Please, if I'm understood to be saying that, then that's not what I'm saying. I've said, that's why I was taking advantage of the debate that happened with Justice Lukhans and Mr. Mkari. I'm saying, assume for now that I accept that they have a right of review. Assume that is. All the Constitutional Court is saying is that right of review is not like everybody in the street might have. In these situations, once the independent panel says there's sufficient evidence, then you cannot deny the people of South Africa the process until it's set aside. In other words, you must, if you have to suffer, quote unquote, in that process until the outcome, so be it, basically. And because why? Because of the constitutional importance of the process that we are engaged in. We're
So
talking
you could have a parallel process.
absolutely. Yes, it prescribes in paragraph 139, thank you, a parallel process. Just as it does the eau de Cral rule, normal eau de Cral rule says. It says, yeah, you can go and fight about this tender, but until it's set aside, it's valid. Why does the law say that? Remember, if I have a case against a normal person, and I can say to the court, please interfere, court, because this let's say it was another contractual thing about a house. It might turn out that this is my house and not that other person. The court can interfere. But eau de Cral was made for that, to say in public affairs, there would be chaos if every time I go and challenge some public act, and then it is stopped. So it created some artificial rule called the eau de Cral rule, which says, in the eyes of the law, it comes from some Latin thing, omnia praesementur, which says that if, in the eyes of the law, that contract or tender will be viewed as valid until it's set aside by a court of law. So this was all the...
But Mr. Mpofu,
yes.
On your argument, does it mean that even if the tender was unlawfully
Yes.
Allocated or awarded, and there was serious criminality in awarding that tender, so that tender will stand until set aside? Are you suggesting that a person cannot come in
No. I'm not
and
saying
ask for an interim interdict pending the review?
No, Justice Frans, again, if I'm saying that, I apologize. No, that's not what I'm saying. I'm saying this, that all things being equal, until and unless the thing is set aside,
Yes.
it remains valid.
Yes.
That's what the Constitutional Court is saying. Now, let me come to your direct question, which was to say this is part A and so on. Now, what the Constitutional Court is saying is exactly against that. So what Mr. Trenkov, not him personally, what the President is seeking is some kind of backdoor Section 18.3 of the Superior Court Act. In other words, to say, I know that this is the default position as put by the Constitutional Court, but because I'm suffering irreparable harm and all those things, I want that to be changed by this court. Now, this court would if and that example actually is apt. If they assume, Justice Lukhansi, for a minute, there was no Section 18.3, then the default position would be that if you appeal, it suspends. But the court knows that, I mean, the Parliament knows that in real life things don't happen like that. And that's why it promulgated Section 18.3 to say, but in exceptional, if you can come to a court of law and show exceptional circumstances, irreparable harm and all of that, that can be reversed. But if there wasn't that, the common law would prevail. Every time you appeal, it would be. But what is more, which is, I'm making 2 points. What is more is that if I'm not happy with that situation, which is your question, then I must go to that court that said, unless and until, I can't come to a lower court. If this court here, as in my example, makes a postponement, I can't go to the magistrate court and say, you know, Justice Lukhansi just did something, Mr. Magistrate, can you reverse it? No.
Yeah, but they are creatures of statute, so they can't interfere with us.
I know. But in other words, the point I'm making, Justice Lukhansi, is that the once that pronouncement is made, a lower court than that made that pronouncement does not have the power, jurisdiction, vires, whatever you call it, to alter that pronouncement. Because you will be altering, believe me, if you gave the order that is asked for here, you'll be altering this, what is said in 139. Because you will be amending it. There is, and that also talks to, by the way, the question of alternative remedy. The alternative remedy that the President has is to go to the Constitutional Court and ask for a variation of the order.
Mr. Khomofo, if
Sorry.
I can jump in here, I just want to,
Sorry, please,
I want
Justice,
to, I want
just to make a note of something so that I don't forget.
Make a note,
Sorry,
by all
thank you.
means.
Yes. Okay.
I want to probe this with you. We have an order that's in relatively neutral language. The order's neutral, paragraph 7. The report goes to the impeachment committee. Now, your argument asks us to read certain things into paragraph 139. I would like to suggest to you that the thought of an interdict may not have even been present to the mind of the Constitutional Court. There's no suggestion in its language that it was. Now, in the same way that when Parliament wants to take away a right in the common law by statute, it must do so in the clearest terms. How much more so for the Constitutional Court to take away somebody's right to come and ask for an interim interdict? How much more so must it say so in clear terms? And by the way, would it have even been competent for the Con Court to make such an order on this case where that was not the issue before it?
Yes. Let me start from the worst case scenario for me. Let's assume the Constitutional Court was wrong. We don't know what happened to them. They normally are so good. There's nothing you can do here in the Western Cape.
No, but your argument is resting on an interpretation, and it's for us, with the greatest of respect, for us to decide whether you're right in your interpretation or not.
Absolutely. In that case, then comes this. Remember the case of Gentikuro, 1977-4. It's a judgment of Trollip J.A. What was said in Gentikuro is that when you, this court, and your relationship is quite correct, when you interpret a judgment or order, you must use the exact tools, endumeni and all that, that you would use for a judge. That's number one. That case also said, you can't just look at, and I take your point, you can't just look at the narrow order, let's say it's a narrow order. You have to look at the judgment as a whole. That is why, Justice Davis, I'm marrying in what I'm saying, the narrow order, 7 and 139, because I'm applying the test in Gentikuro. Because you can't look at 139 in isolation,
Sure.
and also you can look at what you call
The order.
Rules, order number 7 in isolation. Now here's the kicker, Justice. Let's go to what you call the narrow order number 7. Let me start. If you allow me, I'll just take one example. Look at order number 3, bracket 4. Just the last few words. It says it must be referred to the. I'm so sorry, Justices. Let's take order number 3. 3.3. In the event sufficient exists as contemplated in Rule 129G, by the way, that answers Mr. Trenko's thing. It's not just sufficient evidence in the air, sufficient evidence as contemplated in Rule 129G, which I've already addressed the court on. It says the matter must be referred to the impeachment committee established by this rule for that purpose. Let's bank that for a minute. So it's not referred there for decoration in the committee. It's referred for the purpose of proceeding with the inquiry. Now let's go to paragraph 7. Then. It says the report of the independent panel, we're talking about this one now. Here we're clear, Justice Leckrans.
No, I agree with you.
Yes,
I agree with you.
It's this one, yeah. Is in other words, the Noble panel report, let me just put it that way, yeah, is referred to the impeachment committee established in terms of Rule NA rules. For what? For decoration to be put on the... No. It's referred there to do that which Mr. Mkari was talking about in terms of Section 237 of the Constitution, diligently and without delay proceeding with the inquiry. And you have to read that paragraph 7 together with what I've said in terms of and then Justice, I don't want to lose this point. 141, Justice, when we started this morning, Justice Legrand referred my learned friend. It says, in such instances, if appropriately regulated by the NA rules, now again, we know now they're talking in general. Once they say in such instances, it's in general. If appropriately regulated by rules, the termination of the inquiry without a full-blown trial may well be justified. The possibility does not qualify the obligation of referral following a positive prima facie finding. It reflects instead the distinct institutional roles of the panel and the impeachment committee, the former determining whether there is a case to answer and the latter determining whether the case ultimately may be sustained. It can't be clearer than that. So what they're saying here is that in those instances, once the sufficient evidence prima facie is passed, then the consequences must follow. This is the point I wanted to illustrate. Again, unfortunately, I've got all these battle scars here. So, this is what happened, justices. Just very, I promise you, I won't be long on this. In the Zuma incarceration cases, there were two cases which have a bearing on this. One of them is the one referred to by Mr. Katz, Zuma versus Minister of Police. In the Zuma versus Minister of Police, we went to the lower court, to the provincial division, and we said, please, you have to interdict the arrest of Mr. Zuma. They said, where do we get the jurisdiction? Because the Constitutional Court said he must be arrested. We said, no, you have jurisdiction because territorially, it's going to be executed here. Which was, even if I say so myself, I thought was a way to get around the problem. The court said, The court said, irrespective of the fact that we may have territorial jurisdiction, we cannot second guess what the Constitutional Court has said. Rightly or wrongly, whether the Constitutional Court was right in saying he doesn't have a hearing, whatever you are saying, Mr. Mpofu, that's not for us. So what did we then do? We did what Mr. Trenkov should have done. We went to the Constitutional Court and asked for a rescission and variation of the order. The Constitutional Court was so...
But isn't there a difference in the Zuma matter than this matter? Because in the Zuma case, if memory serves me correctly, it was the Constitutional Court that imposed a sanction on him.
Yes.
So it can only be them that can then make a determination as whether they want to rescind it or stop it.
Absolutely, but that's what I'm saying. In this case...
But in that instance, the Constitutional Court did not decide whether the President has no right for interim relief.
No. In this court, the Constitutional Court imposed the ignominy of the process continuing until it is set aside. You, like the court in KZN, cannot then say if that ignominy is rightly or wrongly imposed. Just like I couldn't go to the KZN court and say, no, he didn't get a hearing and all that. They said, well, go back to them. And that's what we did. And this is what the Constitutional Court said, with the greatest respect in that case, to support our approach.
Yes.
The Constitutional Court said that paragraph 49 of the Zuma, what's the name? It's a 2021 BCLR, I'll get the correct citation now. At paragraph 49, the Constitutional Court said the following, sorry. Yes. And I'm saying this apropos, remember now, we're now in the Constitutional Court because we're saying you must vary your order. Now, the issue, the other side, now turned around and said, no, you can't come here because you can't just have direct access and all those things. The court said, no. This is the only place they can come to. And so they found out against us on the merits, as we all know. But they said, where else are they supposed to go? Because they can't go anywhere else to change this. If we were wrong, or all the grounds in Rule 42 applied, we are the only people, and this is what the court said. Of course, it would be inappropriate for any other court, read Western Cape High Court, to entertain, let alone do anything, to entertain a rescission application pertaining to an order made by this court. Similarly, although direct access is only granted in rare and exceptional circumstances, Rule 42.1 would never find operation in respect of an order of this court without direct access being granted.
But
So
the
what this
applicant
court-
doesn't ask us,
Sorry.
but sorry, the case of the applicant is not for us to rescind the order of the Constitutional Court.
I'll show you that it is. I'll show you that it is. I'm saying it is. They might not use those words, but what they are saying is that in 139, that court, the Concord is saying that the show must go on until and unless. But you, court, must say the show must stop now. Don't wait for the until. Take the example of the first of let's say the Concord said this thing must carry on until the first of.
No, but what the applicant is saying is, my understanding is temporarily stop this because we want to review this matter.
Yeah. No, but
no.
whether you are stopping it temporary, whatever, you are stopping it. The point is, if you are stopping it, you are interfering with that order. In a small way, I might accept, but the point is that you have no power to interfere in a big way, a middle way, or a small way with the order of the Constitutional Court, even if it's wrong. You just don't have the constitutional power to
Mr. Mapofo, I can guarantee you, as the bench sitting here, we don't want to imply anything that the Concord got it wrong.
No, absolutely. No.
That's not our territory.
Fair enough.
And not our place.
Fair enough. I'm saying that just for emphasis. And that goes back to my original point about separation of powers harm. That you are being asked, really, let's cut all the legalese. You are being asked not only to interfere with a constitutional court order that makes it clear that the show must go on, but also, as Mr. Katz said, to go into another lane of the legislature. So the separation of powers harm here is egregious. And the outer says that you must carefully, not just consider, carefully consider separation of powers harm and refrain from intruding into let alone trying to reverse. And again, I'm exaggerating for effect. I'm not saying this court has any inkling to do that. But let alone reversing, altering, amending slightly or whatever an order of the constitutional. You cannot do that. So
5 minutes.
5, okay. Well, if it's 5 minutes, then let's do this. Let me give you, I'll give a rounded, a more sequential ordering of my argument. If you go to, there's a case called Makanya versus University of Zululand. This court knows it. 2010 bracket 1 SA, page 62 SCA. It's the judgment of Newton JA on jurisdiction. He says at paragraph 29 that just the last sentence. There's the other. Oh, yeah, sorry. Because I don't have time, I'll just read the last sentence of paragraph 29. But in both cases, he's made differences about how to plead jurisdiction and so on. The issue of jurisdiction must be disposed of first, because upon it depends the power of the court to make any further orders. In other words, if we are correct on jurisdiction, you may not make any other order because you just don't have any power. Whether it's the prima facie, outer, and all these nice things, and that's the end of the case. Of course, the court might, in its judgment, deal with these other things ex abundante, because we know the specter of what do they call it? Litigation that is fragmented, so that if there's an appeal or whatever, then that court must have the views of the obiter dictum. But in reality, if you find that we are correct on the jurisdiction point, that's the end of it. So that's the first point we make on the interlocutory points. The second point we make is Mr. Kasiboto's issue on urgency. We say the president's problems of urgency do not start on the 8th of May. They start in the 1st of June 2022 or the December 2022. The president is obfuscating when he says to this court, because the National Assembly voted against the report, then the matter became moot. It can't. How did it become moot? The president cannot speak with both sides of his mouth. If he is here because of irreparable harm, which is reputational, then that irreparable harm started when the report was released. And there was no reason for him to abandon the Constitutional Court review, which could have resolved all these things a long time ago, long before the EFF 3 judgment. So, and then by the time we come to this one of 8th, it's already been pleaded by everyone. So we're saying there's no urgency. Let me jump. In medias res, another red herring. Mr. Tengov says, there's a Constitutional Court judgment, oh gosh, it was an appeal from this court, which we in these public protector cases. It's, please, just add 1 more minute, Justice. Injury time. To the other 5 minutes. I'll find it now.
I'll give you 1 minute injury time.
At the end. And not now. When I need it. Anyway, I'll give the citation even tomorrow. Paragraph 16 and 17 of the Constitutional Court case was a judgment of Justice Mhlandla in the public protector case, when the one that gave us the victories on
Saldana's case.
Yes, on the legal representation and so on. Paragraph 16 and 17 of that case says the following. The speaker had argued in that case, in the old days when the speaker was not abiding, when they were opposing the impeachment proceedings. The speaker said the process of impeachment carries 17 steps. And they were right, and then they outlined them. Mr. Breitenbach typically put them all there. And then, so what we're doing here is that if this court doesn't take seriously this argument in medias res, literally, and I'm exaggerating again, it means at every of those 17 steps we'll come here. No, complain about this, give us another interim order, then we deal with that one. Now 5 years later, we have another one. This is what Mr. Tengov calls Stalingrad. That's all that they're doing. They're just stalling and stalling and stalling and stalling. Now, and this is the point about in medias res. Mr. Tengov, one of my learned friends says there's one process, and that's what we say as well. It's either it commences, 16 and 17. It either commences or it doesn't commence. And this court says, yes, paragraph 16 says, the rules are in part 4 of chapter 7 of the rules of NA and provide a 17-step process for the removal of an office bearer. The grounds for removal include misconduct, incapacity, and so on. And then it says, the process commences, this is paragraph 17, when any member of the National Assembly gives notice by way of a notice to initiate a removal proceedings of an office bearer as contemplated in section 194. In other words, the process commenced when Mr. Zungula, so you can't in the middle of the process want to interdict it, or that's where the in medias res argument comes. But let's be kind. Let's assume Mr. Tengov is correct, that it is possible to compartmentalize each step. even if that is the case, let's say now we're in step 7 or whatever. Within that step 7, which is the referral of the post-referral phase, that has already happened as well. Because the committee has said, it has elected a chairperson, it has decided on this matter here, and therefore you can't somewhere in the middle of that process say no. Now,
But Mr. Mpofu, on that argument, what will the effect be if the review application is successful?
No, you see, Justice Lekhanj,
Will not the same effect be that in the middle of the whole process it stops?
no, but if that happens, then the Constitutional Court said at that point and that's why the words until and unless mean exactly that.
Yes.
It says at that point it must stop, not now.
Okay.
So the effect of that happening would then be the stopping. But before that point, nobody, not this court, nobody, except maybe the Constitutional Court, can stop the process. Now, so that's the immediate response. I'm just
Okay, you got 3 minutes left now.
yes, thank you. I'm just disposing of that. Yeah. So they can't do it. Neither can this court. Then there's a point which Mr. Tengov has not addressed at all, which is the issue of the non-joinder of the president. It's a serious point.
You mean his office?
No, the president, yes, the president, as in the office here.
Yes.
Now, here is the issue. These proceedings have been brought not by the president of South Africa, by Mr. Cyril Ramaphosa, in his personal capacity, using his private lawyers. Very good. We like that. But what is supposed to happen? He then says when he talks about irreparable harm. Oh, please, court, you must remember that this matter goes beyond my personal interest. It affects the office of the president. Well, if you do that, then you must join, because in law, unlike in real life, Mr. Ramaphosa and the president are two legal personae. And so it's a non-joinder of a person of necessity. And it's not a small point. In the, sorry, Justices, in the Erasmus J case, I think it was paragraph 77. Yes, Erasmus J and the others, that's what they said about the public protector. It says the applicant on the papers is the office of the public protector. Advocate Mkhwebane is different from the office of the public protector. This may seem somewhat technical, but it's nevertheless vitally important. Advocate Mkhwebane's reputation has been sullied on numerous criticisms and various judgments and so on. On the contrary, the parliamentary impeachment process presents Advocate Mkhwebane with an ideal opportunity to remove these alleged blemishes on her reputation, Justice Francis's point. In other words, firstly, you differentiate between the two, but also you can't borrow now the reputation and use it when it suits you and so on. So that's the point we make. Then the abuse of process point, we stand with the papers, because our point is that all those allegations have not been responded to, and therefore the court has nothing to weigh against. And that, of course, is important also on the question of costs. Having commended the president for coming as a person, then we say, just for the sake of clarity, the costs that are imposed by this cost against him, if he loses, must be personal costs. Because in any event, he can't complain. He also came on a personal basis. So there are three legs. I think I have 1 minute now. One, we say the court has no jurisdiction. End of the story. Two, we say on the grounds of review, such as they are hopeless, they have no prospects of success, they are all obfuscation, sufficient evidence, prima facie, this, that, and the other. We've made the point there. Then we say, even if we might be wrong about that, and let's say it doesn't, it has a prospects of success or likely to succeed. The other requirements of outer have not been met by any stretch of the imagination. No prima facie right. There's alternative remedies. I've just given you one, an extra one of variation or rescission. They could have done an urgent review. There's no reason why we're not sitting here now doing the review. They could have done an urgent review application. That's an alternative remedy in terms of rule.
Just on that score, it appears that there were some problems with the dates. There was an earlier date given for the review, but some of council was not available.
Yes, there was. No, there was a later date.
Oh.
That one was even worse. That was a date suggested by my learned friend, Mr. Katz, which was the 14th of August. And the president says he was happy with that date. In other words, the president would have come here to do a Part A application on the 14th of August, and then 2 weeks later come for Part B. I mean,
No, I thought it was Part B. That was
no. Yes,
No, it
the
was-
first. Yeah.
it was for Part B.
The first set of dates was for Part B.
No, what happened?
Sorry.
What happened was before the intellect was brought, there was a case management meeting for Part B, and that resolved to be heard on the 2nd of September.
Yeah, but wasn't there an earlier date given?
There was a debate about dates, that was the first available date.
Oh, right.
But then when it came to the intellect, the JP sat on the case management meeting with Judge Erasmus because he had case managed the Part B. And I suggested, which Judge Erasmus would seem to think was a good idea, that Part A and Part B should be, let's call it Constantine, consolidated. There's no point in having this and then 6 weeks later, it's crazy.
No, I accept that.
And then what happened was they just couldn't get the dates to fit in an expedited Part B, and the president was the one who said, no, September's too late, that's why he wanted this thing. That's what really happened.
Yes.
Thank you, Mr.
No, it's all, but let's assume Justice Lekhanse that it was about Part B. Then it would have been worse, because we would have been here now, and then 3 weeks later,
Yeah,
we
no,
would be doing
that's-
Part B. Yeah. So the point of the matter is that this is completely an exercise in frivolity, in the sense that, you see, it goes back to Mr. Kasiboto's point. Remember, what do we say? What is the test for agency? That you will not get redress in due course. Here, they are going to get redress in earlier than due course, now in 6 weeks' time, or whatever number of weeks. So why are we here? So you can't come and say, no, I only want a modest interdict. Why? Because in a few weeks' time, you're going to be having your Part B. So we therefore say, and I don't want to go through the whole shopping list of outer, but we say in separation of powers harm, with the greatest respect, my lady and my lord, please go through those papers and find out where the president addresses separation of powers harm. Such an important requirement of outer. Zero. Nowhere. Go through those papers and see where the president says this is an exceptional case. Zero. Go through those papers and see where the president says this is the clearest of cases. Zero. How can you succeed? Unless if we're now also going to overturn outer while we're overturning higher decisions of higher courts. I mean that in jest. But the point is that when there are stipulated requirements by no less than the Constitutional Court, which says you must deal with this, you must show mala fides, show me where they allege that there's mala fides, as in the Gould case, zero. How can they succeed? They can't. With the greatest respect, this court, with the greatest respect, must return a decision that says all this is all very, very interesting, but we choose to stay on our lane. And we are not going to, and we're also as the court pleases.
Have you got anything further? Thank you. The right of reply will be tomorrow morning at 10 o'clock. Court will adjourn.